Shall we start now?
Yeah.
Yes, ma'am.
Good evening. So, on behalf of the Indian Fertility Society and the IFS SIG Law and ART and the IFS North Zone, it is my great pleasure to welcome all our distinguished faculty members, moderators, panelists, and participants to today's webinar From Consent to Compliance Legal Essentials in Fertility Practice. As assisted reproductive technology continues to evolve, so does the legal and the ethical framework that governs our practice. So, staying updated with ART and Surrogacy Act consent processes, regulatory requirements, and emerging medical legal challenges is no longer optional. It is an integral part of delivering safe, ethical, and patient centric fertility care. We are privileged to have with us an esteemed panel of experts, including our senior clinicians, legal professionals, and leaders of the Indian Fertility Society, who will share their invaluable insights and practical experiences. Their expertise will help us get better. They'll help us navigate better, and also the complexities of modern fertility practice while ensuring compliance with the evolving legal landscape. So we will encourage all the participants to actively engage in the discussion, ask questions, and make the most out of this unique opportunity. Thank you all for joining today. With that, I warmly welcome Dr. Sonia, and I would like her to please welcome the audience. Before we start, we'll just have a brief introduction about ma'am. I'm sure that ma'am doesn't need any introduction. We're all well aware of her. She's a chief clinical mentor at Nova IVF Fertility India. She's a chair advocate committee IFS 2018 to date, past chair infertility committee Foxy 2014-16, past president Indian Fertility Society.
Let's stop. Let's just say I'm here as a part of this SIG. That's enough. Yeah. Thank you so much.
So over to you, ma'am.
Neeti, would you first want to introduce the team for this SIG first before we go ahead?
Sure.
You know, Dr. Parag, I don't think people know him. So
Yeah.
please introduce the three of us.
Yeah.
And then after that, I'll say a couple of words. Okay?
Sure, ma'am. Sure, ma'am. Good evening, everyone, and I bring warm welcome to all of you on behalf of SIG Law and ART. First of all, I would like to thank Dr. Neena Malhotra.
Niti, make your sound loud.
Louder.
So I would like to thank Dr. Neena Malhotra ma'am and Dr. Shweta Gupta for giving me this opportunity to be a co-convener of this SIG. We are fortunate to have Dr. Sonia Malik ma'am as a mentor. We know that she has always been active in this area of law and ART, and she is in connect with a lot of people, up there in the ART board also. And then we have Dr. Parag Nandi, whom we all know. He has already brought out, some books also, kind of books on ART laws, how to interpret them and all. And then we have Advocate Mohini Priya. Advocate Mohini Priya, if you all know, she is working as a Supreme Court advocate, and she has been instrumental in as a mediator for a lot of cases related to ART. So she will be also be giving a talk today. And I would like to thank Dr. For the North Zone IFS team for coming along with us. And this first webinar we are going to do with the North Zone IFS team, we will get to know what all problems they are facing as far as law and ART compliance is concerned, and it will be a learning experience for us also at the center. So with these words, I would like to invite Dr. Sonia Malik ma'am to say a few words of blessings as we start.
So thank you once again, Neeti. Thank you, Dr. Umesh, for having this webinar, the first webinar of this SIG group. I think this one is a very important SIG because you know that we are as a group, as an ART group, we are riddled with law and we are riddled with so much of suspicion as far as we doctors are concerned, especially in this segment. And unfortunately, the recent incident about DNA mixing and about all that is coming up in every channel and every paper is actually causing a lot of disturbance. And so this particular webinar is of great importance to all of us who are practicing ART. We have to be very, very compliant in whatever we are doing, and we have to be very careful, read between the lines. I think that is why this SIG has a very different flavor. We have clinicians, and then we have Parag over here, who is a very senior embryologist. He is going to give us the inputs from the embryology group over here in this SIG. And then, of course, we have Mohini, who is such an efficient and great lawyer. She practices in the Supreme Court, and she has actually been the lawyer for so many such cases that have come up after the ART Act came up in 2022. As we go along, as we keep on having more webinars, you will learn more and more about what is happening in the law, in the segment of the law, as well as in the ART segment, as to how we have to go about it and how we have to counter these problems that we are coming. We are, as it is, reeling under the problem of submitting the retrospective data of the last 4 years. We know that we are all, having a big problem facing doing that. But of course, we have been challenged, and so we are doing it, of course. And as Parag would tell you, we have made a representation to the national board to exempt us from that, but we haven't heard from that as yet. And June is nearly over, so we all have to submit whatever we have been able to collect. With that, I think let us go on and see how we are actually trying to be compliant with this act, and how we are actually wanting to do better and better, so that nobody tells us or lays a finger on us, and we are actually within the premise, or within the precincts of this of the law. And we are actually very law abiding and very fear. Doctors as such are not very bold. We are a very timid kind of a society. We only like to do our work and get away with it. हमें कोई मुसीबत नहीं पसंद. But what happens is we eventually land up in some kind of a problem or not because we want to get into it, but हमसे हो जाता है. So वो होना नहीं चाहिए. That is what we are doing, trying to tell you all, and that is what we are going to learn from this webinar. With that, let's go on and let's start the proceedings.
And I want to add few words
Please, Dr.
on behalf of the Northern Zone. I would like to thank the SIG team as well as IFS for involving us, and I would like to thank
voice.
Participated in the program, and they are joining also. More and more delegates are joining now, and I am very sure that this webinar is going to, help them a lot. Thank you.
And another thing is, we are very much available to all of you. If there is anything that you would like to ask, even after this webinar, we will. I think Neeti will put in the email IDs of all of us in the chat box, and then you can get in touch with us, and we would invite more members in this SIG. It will become a very good group if more of you join us, and we make it a real wholesome group. So that is the idea. Thank you again.
Yeah, ma'am, a very valid point. So those who are interested in this group to be member of Law and ART, because we'll be doing a lot of activities in these 2 years, can just, tell me, and I can make them join the SIG group. And right now also in the chat box, whoever has any questions, while we are discussing, can always put up the questions. We have a lot of experts on the board, and we will answer them. Thank you.
Thank you.
We'll begin with the first session. So this session 1 is frozen embryos, broken marriages, and difficult choices, emerging legal challenges in IVF practice. With us, we have Advocate Mohini Priya. She is advocate on record at Supreme Court of India with over 14 years of practice in constitutional litigation, reproductive justice, and gender law reform. Her areas of expertise are constitutional litigation, reproductive law and ART, surrogacy law and policy reform, gender justice and equality, healthcare law and accountability, child protection and welfare, organ transplant and health law, and workplace equality and POSH. We welcome you, ma'am. And to chair the session, we have Dr. Neeti Tiwari. She's co-director, Center of IVF and Human Reproduction at Sri Gangaram Hospital, New Delhi. Dr. Sheetal Jindal, Senior Fertility Consultant, Jindal IVF Center, Co-Convener SIG Applied Genetics, Indian Fertility Society of New Delhi, Treasurer Chandigarh Obs and Gynae Society, Treasurer Greater Chandigarh Chapter IFS, and she has more than 15 years of experience in infertility. Dr. Yogita Dogra, She is DM Reproductive Medicine, FSCOG, Consultant and Director, IVA IVF Super Speciality Center, Shimla, Himachal Pradesh. Secretary IFS Himachal Pradesh Chapter 2026-28. So we welcome you all and will like to begin the session now.
Thank you so much, Shagun, for that introduction. And without wasting any time, I think I will just like to take you through the...
Just a minute before we start, I
Yes.
just wanted to, because I can't see them, Dr. Neena Malhotra and or Dr. Shweta, if they have joined, can they unmute themselves? Because they said they would join. Maybe they are busy. While you can start sharing, Dr. Mohini, but I think they are
Yes,
not.
I'm just sharing the screen.
They haven't joined. They haven't come.
joined. Okay, ma'am.
No.
Ma'am, is my
Well,
screen visible now?
Yes, but you put it
Yes.
on slideshow. Put it on slideshow, please,
Yes,
Mohini.
yes, yes. Slideshow. Fine now?
Yeah, absolutely.
Yes. So I'll just begin. I'll just take you, start with a brief overview of the legal framework and then discuss some real life and hypothetical situations that fertility specialists commonly face, together with some practical ways to navigate the legal uncertainties and the statutory gaps regarding consent under the ART Act. So, as we know, the ART Act is India's first comprehensive legislation regulating assisted reproductive technologies such as IVF, ICSI, gamete donation, embryo cryopreservation, and related procedures. Its key rules include embryos may be stored for up to 10 years with written consent. Clinics must obtain consent from both genetic providers from extraction till implantation. Donation, sale, or research use of embryos required explicit consent, and violation can lead to fine and imprisonment. Now, at its core, the Act is founded upon a single principle that reproduction through assisted reproductive technology must be based on informed, voluntary, and continuing consent. Now, the relevant legal provisions here are Section 22, read with Rule 13, and Form 9 is also important for cryopreservation of embryos. So, Section 22 of the ART Act is the foundation of the consent framework governing IVF and other assisted reproductive procedures. It mandates that no ART procedure can be undertaken without the written informed consent of all concerned parties and requires specific consent for the creation, storage, and use of gametes and embryos. Most significantly, Section 22, subsection 4 adopts a continuing consent model by permitting either member of the commissioning couple to withdraw consent at any time before embryo transfer. Consequently, the creation and cryopreservation of embryos do not automatically confer a right to implantation, as fresh and continuing consent remains necessary until transfer into the uterus. Now, going to Rule 13. So, Rule 13 F4 of the ART Rules 2022 provides for various consent forms, starting from Form 6 to Form 13. Form 9 complements Section 22 by requiring parties to provide advanced directions regarding the fate of cryopreserved embryos and gametes in situations such as death of one of the parties, whether it should be handed over to the spouse, allowed to perish, or used for research purposes. Now, I'll just take you through the consent journey under the ART Act. So, consent is required for commencement of ART treatment, retrieval and use of gametes, creation of embryos, cryopreservation of embryos and gametes. Then Rule 13 deals with the death of the spouse and directions in that case. Consent required for embryo transfer, withdrawal of consent under Section 22(4), consent required for donation of diseased embryos for research, use of unused oocytes for research, and perishing and donation of stored embryos. So we can see that consent is not a one-time signature, but it is a continuing legal process throughout the IVF journey under the ART Act. Now we come to the very important section, which is the gap in the law. So while Rule 13, read with Form 9, addresses the death of a spouse, they do not address the situation wherein there is a divorce or separation, there is a marital abandonment, domestic violence, there is an absconding spouse or malafide refusal of consent, and as well as irretrievable breakdown of marriage. Thus, while the law provides a mechanism for deciding what happens when a spouse dies, it remains silent on what happens when the marriage itself breaks down. Now, why this is important in IVS practice is because disputes are increasingly arising now, not because a spouse has died, but because the relationship has ended after the embryos have already been created and frozen. So while the ART framework answers what happens if one spouse dies, but it does not answer what happens if the marriage dies. And this legislative silence is at the heart of many emerging embryo disputes in India. And this highlights the need for clearer provisions dealing with marital discord and embryo disposition, which I'll be dealing with in the later part. So this is the same. These are just the emerging challenges, what the ART framework addresses and what it does not adequately address, that I've already discussed. Now we come to a very important legal and ethical question, which is the right to become a parent versus the right not to become a parent. So we've just come up with a hypothetical situation here, that imagine there is a married couple. A is the wife and B is the husband, who have been trying to conceive for several years. They decide to undergo IVF and successfully create and freeze embryos. Now, over the next year, A undergoes multiple medical procedures and significant emotional and financial hardship. However, before the embryo transfer can take place, serious matrimonial disputes arise and the couple separates. Now, at this stage, A wishes to proceed with embryo transfer, which is the wife, and the husband withdraws his consent and no longer wishes to become a father. Now, these kind of cases we regularly deal with in court. There was recently one filed in the Bombay High Court and then another one in the Delhi High Court. Both of them were mediated. So no proper law could come up even after that. But now there are two arguments to this. A's argument is the right to become a parent. Since she has undergone the physical burden of IVF, she has invested considerable emotional and financial resources. And due to her age and decline in fertility, the frozen embryos may be her last realistic opportunity to become a biological mother. Therefore, denying embryo transfer would effectively deprive her of motherhood altogether. Now, B's argument is that circumstances have changed and the marriage has broken down. Parenthood carries lifelong emotional, legal, financial responsibilities, and reproductive autonomy also includes the freedom not to become a parent. Therefore, he should not be compelled into fatherhood merely because he once consented to IVF. Now, what is the legal and ethical dilemma here? The difficulty is that both the rights are legitimate. A seeks her right to become a parent, B seeks to exercise his right not to become a parent. The law is therefore not dealing with a right versus wrong, but with a conflict between two competing aspects of reproductive autonomy here. So this is the central and ethical dilemma at the heart of modern embryo disputes and IVF litigation across the world. Now we are just coming up with some practical suggestions that how can ART clinics avoid litigation. So first suggestion is to have an embryo disposition agreement. Second is mandatory patient counseling. Then there are mediation mechanisms. And last case is the judicial or regulatory review in exceptional cases. So I would just like to take you through the concept of embryo disposition agreement, which is right now not so prevalent in India, but is being used in many other countries of the world. So what is an embryo disposition agreement? An IVF clinic can and should have a separate embryo disposition agreement, which is in short EDA, provided it is consistent with the ART Act and the ART rules, public policy, and does not purport to override any statutory requirements. Now, the mere absence of an express statutory provision does not prohibit contractual allocation of rights and responsibilities in situations that the legislation does not comprehensively address. So while the ART framework contemplates multiple forms of consent like consent for IVF, consent for embryo freezing, consent relating to donation, research, perishing, and other procedure-specific consents. What is striking is that while the rules prescribe consent for several stages, they do not comprehensively address disputes arising from divorce, separation, incapacity, remarriage, abandonment, or conflicting claims over frozen embryos. The ART Act regulates embryo creation and storage, but it does not provide a complete code for embryo disposition disputes. In that interstitial space, a carefully drafted embryo disposition agreement serves not as a substitute for the law, but as a risk management instrument that records the parties' intention and assists clinics in navigating foreseeable disputes. Nevertheless, when there is an actual dispute, particularly after marital breakdown or the death of a partner, the clinic should ordinarily refrain from acting solely on the agreement and should seek appropriate judicial directions. So, what does an EDA entail? So, before freezing of embryos, the couples can decide what happens upon divorce, separation, death or incapacity, donation, destruction, and future use by one spouse. So, such agreements reduce the uncertainty and future litigation and provide greater clarity to fertility clinics. Accordingly, an EDA would probably be treated as a persuasive evidence of the parties' prior intentions, even if the case is taken to court, rather than as automatically binding upon the parties. So, as discussed, while the EDA does not create substantive rights contrary to the ART Act, it records the parties' intentions regarding contingencies that the statute does not expressly regulate. So, this is analogous to advanced medical directives or organ donation authorizations, cryopreservation instructions, or consent regarding research or disposal of biological material, which is already provided for in the ART Act. So, now, what the agreement can safely cover. So, for IVF clinics, an embryo disposition agreement should ideally address disposition upon divorce or separation, death of one or both of the partners, inability to contact one party, prolonged non-payment of storage fees, maximum storage period, donation for research where legally permissible, destruction after expiry of statutory storage, mechanism for dispute resolution, governing law and jurisdiction, as well as acknowledgement of independent legal counseling, and most importantly, an express clause stating that the agreement is subject to the ART rules, acts, and any future amendments. Now, what it cannot cover is anything that overrides the mandatory provisions of the ART acts and rules. For example, it cannot authorize embryo use contrary to eligibility requirements, permit transfer to third party where prohibited, authorize commercial dealing in embryos, waive statutory consent requirements, or defeat rights expressly created under the Act. It would therefore function as a supplementary contractual document and not as a substitute for statutory consent as required under the Act. Now, some examples as to the language of the EDA. That the agreement should not state that the wife may use the embryos irrespective of any future withdrawal of consent, or that the husband permanently waives all future objections, or that the clinic may transfer embryos despite subsequent objection by one genetic parent, as these may be challenged in court as violating the reproductive autonomy, Article 21 rights, and the principle of continuing informed consent as contemplated under the ART Act. Now, the safest and most defensible form of drafting of an agreement would be that in the event of separation, divorce, marital discord, death, or incapacity, the parties express their present intention that the embryo shall be dealt with in the following manner. And then you may just add that the clinic shall not be obliged to act upon such direction where a dispute exists, where consent has been withdrawn, or where doing so may be inconsistent with applicable law or judicial directions. So this preserves the evidentiary value of the agreement while protecting the IVF clinic. Now, these are just some important Indian cases that we had dealt with. So it was Shazia Mir versus Union of India, which was filed before the Bombay High Court. Same issue, that the petitioner underwent IVF and embryos were cryopreserved with the husband's consent. And following marital disputes, the husband withdrew cooperation and the clinics refused embryo transfer without a fresh consent. So this case raises important questions like, can a spouse who previously consented indefinitely block embryo use? Does reproductive autonomy include the right to use already created embryos? Can consent become a tool of reproductive coercion? And this matter highlights a major gap in the present legal framework. Another case was BTS Manjula Devi versus Union of India. Again, Karnataka High Court, same issue. This was also settled through mediation. So no judgment came. Now, I'll just like to take you through a hypothetical situation that basically encapsulates everything that we have discussed till now. So A is the wife and B is the husband. After years of infertility, undergo IVF and create 6 embryos which are cryopreserved. At the time of freezing, both happily consent to becoming parents. Now, before embryo transfer, the marriage breaks down and divorce proceedings begin. By this time, A is 43 years old, and doctors advise that the frozen embryos may be her last realistic opportunity for biological motherhood. When A approaches the clinic for embryo transfer, B withdraws his consent under Section 22(4) of the Act. Now, A argues that these embryos are my last chance to become a biological mother, while B argues that I should not be forced into fatherhood after the marriage has ended. So, what is the key takeaway here? That most embryo disputes arise because couples plan for embryo creation, but not for relationship breakdown. So in these cases, an embryo disposition agreement forces the couple to answer one difficult question in advance, which is, what should happen to our embryos if our marriage does not survive? And perhaps the most important question for all IVF specialists is, should the law wait for a dispute to arise, or should it encourage couples to plan for it before the embryos are frozen? Now, there are several other legal risks and safeguards for IVF clinics and how they can mitigate these by way of consent forms. So, the first example, if there is a divorce after embryo freezing, so there is a legal risk involved that if the clinic transfers the embryo despite the husband's objection, it may face allegations of unauthorized use of genetic material, violation of consent requirements, as well as civil liability and possible regulatory consequences. Now, what is a practical safeguard here is, again, you can just have an embryo disposition agreement, especially addressing these issues. And the agreement should clearly state whether both parties' continuing consent is required or any prior directions regarding embryo disposition will prevail. In the absence of clear statutory guidance, clinics should refrain from acting until the dispute is resolved by agreement or judicial order. This is important. Another case is where one spouse disappears or becomes unreachable. In this, the legal risk is that, can silence be treated as consent? So the answer is almost certainly not. And the practical safeguard that the consent form should address are procedures where one party become untraceable, periodic renewal of contact information, and consequences of prolonged non-response. Along with this, the clinics should also maintain documentary proof of attempts to contact the absent party. Third case should be the death of one partner before embryo transfer. So the legal questions that may arise is, did the deceased consent to posthumous parenthood? Did he authorize posthumous use of embryos? And can a child be conceived after his death? So this is already covered under Form 9. So I think we can just stick to that. Fourth case would again be the husband revokes consent on the day of transfer. Now, the clinical dilemma here is that the wife has already incurred physical, emotional, and financial costs. And the legal dilemma is that, does earlier consent prevail, or can consent be withdrawn until transfer? So the practical approach here would be that the clinic should treat consent as revocable until the point defined by law. They should obtain fresh written confirmation immediately before every transfer and have clear internal SOPs regarding last-minute withdrawals of consent. Then we can have disputes over embryo destruction, So again, the clinics should, the consent form should specify the duration of storage, responsibility for payment, procedure upon expiry of storage period, and steps to be taken in the event of a disagreement. Another situation could be remarriage of one partner. So again, the embryo disposition agreement should specifically contemplate remarriage and future family structures. Then there comes the case of incapacity. So while the rules take care of death of one of the parties, but they do not, that does not include incapacity of one of the parties. So again, this can also be mitigated by way of an embryo disposition agreement, that who exercises reproductive decision making on behalf of an incapacitated person, whether it is a guardian or spouse, or that can be taken care of. Now we come to cross-border complications. So there is a hypothetical situation that the couple creates embryos in India. One spouse moves to New Zealand and the other remains in India. Now the parties disagree regarding transfer, storage, and export of embryos. So what are the practical challenges here? That there are conflicting laws, jurisdictional disputes, recognition of foreign orders, and embryo shipment restrictions. So the legal safeguard here would be that the consent form should contain governing law clauses, jurisdictional clauses, and dispute resolution mechanisms. Now, another situation that may arise is the pressure on clinic to take sides. Suppose the wife produces an interim order from a family court, the husband simultaneously serves a legal notice objecting to embryo use. Now, the practical advice here would be that the clinics should never become arbiters of family disputes. The role of the clinic is merely to preserve embryos safely, maintain neutrality, follow valid judicial directions, and avoid making legal determinations in such cases. Now, some practical recommendations for ART clinics as regards consent. From both a medical, legal, and litigation risk perspective, I would recommend that clinics obtain 3 distinct layers of consent. First is the statutory consent forms prescribed under the ART rules, that is Form 6 to 15 as applicable. Second would be the procedure-specific informed consent for each stage, which is ovarian stimulation, oocyte retrieval, fertilization, embryo transfer, cryopreservation, donor gametes, etc. And the third and most important that we just discussed, which would be very useful in covering the legal gap that we are talking about today, would be a detailed counseling record that should be maintained for every patient. So where embryos are created or cryopreserved, this should be supplemented by a separate embryo disposition agreement, setting out the parties' advanced directions regarding the future use, storage, transfer, or disposition of embryos in the event of contingencies such as death, divorce, incapacity, or prolonged non-contact or non-payment of storage fees. Now, coming to the concluding remarks, the emerging disputes involving frozen embryos demonstrate that modern reproductive medicine has advanced faster than the law. While the ART Act provides a robust consent framework, it remains largely silent on situations involving divorce, separation, abandonment, and reproductive coercion. So the real challenge is not deciding whether consent should matter. It must. But the real challenge is creating a legal framework that protects both the right to become a parent and the right not to become a parent. So for IVF specialists, lawyers, and policymakers, the focus must now shift from a consent-based model to a consent plus planning model, ensuring that future disputes are addressed through clarity, counseling, and informed choice rather than litigation. Thank you.
Excellent talk, Dr. Advocate Mohini. And I was just thinking if we could have, this kind of master class from you every month, we really need to be
My pleasure always. I hope I was able to put the
embryo
points well.
disposition agreement is one thing
Yeah.
which I was not aware of at all, and it is such a thing that which can protect us, in
Many states in the US have this embryo disposition agreement. So
and
I
even
don't think
at
any
our
of the
center,
clinics in
our center also we went ahead, we had this case which was going on for so long after
yeah.
divorce, who is going to be the owner of the embryo, and the case
Right.
went on and still is going on in the court, and the embryos are lying with us and don't know what to do with them. They are safely lying with us.
Right.
And one more problem which we face, sometimes, that when the patients come, they are not carrying their marriage certificate. So
Mm-hmm.
one of our consultants, she faced this problem that a couple came to her for IVF,
Yeah.
and they kind of got registered for IVF. The process was also went ahead, and then when the day the lady was supposed to have the embryo transfer, another wife emerged with the
Oh.
police that this is my husband and he's trying to do IVF with another woman, and I am the legal wife. So all these kind of
Yeah, these
scenarios.
relationship
And
dynamics are very
it was
difficult
just
to.
that we were like half an hour away from doing transfer. We're
Oh
just
my
half
God.
an hour away from doing the
Yes.
transfer. The police came and we stopped the transfer because the wife complained. The true wife,
Exactly.
actually.
Yes.
So, all these
So I don't
situations.
think the law can contemplate all these unique situations. So that is why I think an agreement of this sort should be useful
Yeah, but
where the parties.
if lawyers like you could bring out some like kind of changes in the rules itself in the next forms, maybe some kind of amendment.
I agree. I'll be making this recommendation to the national board also.
Uh, can I say something about this?
Yes, ma'am.
An excellent lecture and an eye opener. The take home from your lecture for me is the legal consent provided in the law are limited.
Yes.
Yes.
We must devise our own consents which are stage specific for every procedure, because every procedure has some kind of risk, whether it is medical legal or
Right.
medical. So like thawing of embryos, we take consent even for thawing of embryos, because
Right.
once you thaw, then after that, if patient withdraws the consent, then there is a problem. So
Yes.
thawing is again, we take a consent. So every procedure has a stage-wise consent. And third,
Yes.
this concept of additional uh, agreement kind of thing, this is new to me. Matlab, we
This is
never
an additional
thought.
safeguard. Yes.
Yeah,
This is
actually,
just
we
a
have
risk
done.
mitigation strategy.
Yeah, we have done this, and we actually put it counseling sheet, but not in the form of an additional agreement. I think we should put it in the form of an additional agreement like you described. So that will
Yes.
safeguard, because counseling sheet does not safeguard. This only safeguards that we have explained,
Correct. Correct, ma'am.
right?
And this should be a part of the counseling sessions also.
Yeah, that
Because
is
once
there.
we agree, this is
Yeah, but types of consent. This is a new idea, which at least
three
I.
levels of consent. Yes.
Thank
Yes.
you.
I just wanted to. I came in between Dr. Moini. Mrs. Moini. It was a very nice lecture, and I just have to. What I could understand from your talk was that IVF is such a complex thing, and any complexity can arise at any point and in any situation.
Right.
So, how far? I mean, how many consents can we take? I mean, this is like with each case, with each situation. I think. Um,
I know not every situation can be contemplated, but
yeah,
we can at
yeah.
least minimize the risks. That's all we
Okay.
can do in this situation, because there
And
can be some unforeseeable situations that come up in the future.
yeah, yeah.
Yes.
And one more thing which I want to ask you, and in fact, I would just try to put my point by discussing a patient. Let's say
Hmm.
there was a couple who came to us, and unfortunately, I mean a very well placed couple. The husband was a lawyer, and wife was also at a very prominent position.
Hmm.
They did IVF with us, and then they never came back for an embryo transfer. Now it's
Okay.
been almost like 2 years. What I could gauge was that it's probably a marital dispute in which they have gone into.
Yes. But are they
So
paying for the renewal of embryos, annual storage fees?
no, they are not.
They are
So
not paying.
these situations, they arise very, very. I mean, they arise. I mean, patients go for an embryo transfer. I
Hmm.
think it's a very gray area as far as renewal of embryos is concerned. That the clinic is supposed to call them. There are three registered males, and in case they don't turn up, then you can discard the embryos. Practically, in our clinic, we are not at all. We are not discarding the embryos in case we don't hear from the couples. Now, is that the right thing? I'm
So
sure a
that's
lot of
like
other
unlimited
clinics must
storage. But
also
in
be.
any case, you can store it only for 10 years, but You can have some clauses stating that if the storage fees is not paid, then you can probably have the right
So
to
just by writing this in the consent form, can it be taken care of?
see. It is always open to being challenged in court, saying that it
Yeah.
is against the statute, but at least there is some form of an understanding between the clinic and the patients. So it
Okay.
will just mitigate the risk for a future legal dispute, but not completely rule it out.
So
No,
this
but the
challenge will
understanding,
remain.
so the understanding between the patient and the clinic is not above the law. So even I have this question that what if
Yes.
we do not hear from the patient, we are obliged to store the embryos for 10 years, which is a very long time.
Very long
And
time.
how many cans will we eventually need?
Yeah.
And we'll have one hospital only for the cans in that case.
Very
Because
true.
yeah, so if we are by law we are bound to
This
keep
is
it for 10
something
years.
you think there should be some amendment to the rules here.
Yes,
Yes, yes.
exactly.
Yes.
True, yes.
Yes.
It should be the patient's prerogative to, it's their property, so they have to take care. And we are taking care of their
certain
embryos.
amendments
So
to the
actually,
rules here. Yes,
Actually, Mohini, this time law is very clear that they can be discarded if
Yeah.
you do not hear from the patient
No,
or the continuation
um,
fees is not.
No, but in
It's
spite
part
of
of the.
that,
It's part
ma'am,
of
the
the concept.
but in spite of
में
that, we
printed है
continue to
10
store
years
We
the
are
तक.
not
embryos.
discarding
Are we
it.
legally
We are
safe?
not discarding
No.
it.
So are we legally safe? I mean, this is one very important question and a very pertinent question with every IVF clinic.
Yes.
What we
Ma'am,
have
Form
started
9
doing
में
is,
printed है 10 years. Form 9 में 10 years printed है
10
हमेशा.
yeah,
So
Yes.
you
हाँ.
can discard the embryos which are more than 10 years and which have not been paid for.
But
More than
ma'am,
10
Yeah.
10 years is a pretty long time.
I mean,
Yes.
10 years is a very long
Store them
time.
for
Very
10
long
years. So
time.
it's not
Store
being
them
Yeah.
paid
for
for.
10.
That
So
should be
there are
an
a few
issue.
questions in the chat box also. So, one of the questions is, okay, marriage certificate is a problem. Can Aadhaar be used if the address is the same? Advocate.
No, marriage certificate, I think, is a must here. You cannot.
That is not written in the marriage certificate or Aadhaar card are the one and the same
some
thing.
documents to prove that you're married. Of course, if in the Aadhaar card.
If the husband's name is on the Aadhaar card, it is a marriage proof only.
So,
No.
so Aadhaar is also not a very reliable source, but
But that is from Government of India, na? So we cannot challenge the Aadhaar card.
Aadhaar is just a number. I
Aadhaar is
think it
not
has
a
got
marriage
nothing to do with the.
tell you
No,
that.
the wife of this or wife of this, that is an ID proof.
Yeah, that's an ID proof.
So that states that she is a married woman with this husband.
Anu, actually, Aadhaar card should have the name as so and so, wife of so and so.
Yes, yes, yes.
If
Only
it is
then.
daughter of so and
Only
so,
then.
we
No,
will
no,
need
we
marriage
don't use
certificate.
that. We don't. Then we
Then we
ask for
need
the
a
marriage.
marriage certificate.
Yes.
Because
Either
advocate,
that.
the problem is that in India, many people do not actually have marriage certificate.
But they have Aadhaar card.
But
Yeah,
but the
because
Aadhaar
I-
now being issued, the Aadhaar now being issued states care of. The new Aadhaars are now stated as care of and not wife of or daughter of.
But if the care of name is of husband, then it is okay.
But how do we know he's the
No,
husband?
How do we
no,
know?
no,
Where
no.
is
So
the
then,
proof?
if he's not the father, then he's the husband.
See,
Only
actually,
two
No,
names
what
can
if
be
they're
there.
in the live-in? अगर live-in में हुए तो भी उसने care of लिखवा दिया. अगर live-in में हुए, what if they're not married and they're on a live-in couple and उसने they are a live-in couple residing at the same place. The Aadhaar could say care of as a live-in partner also.
Is it like that? Aadhaar can write
So
like that.
this is also
Advocate
New
hypothetical.
Aadhaars are now care of.
Advocate Divyanshu is
actually,
also there.
what I understand, Mohini, you can clarify this, that no certificate is foolproof as far as even marriage, date of birth, or anything. It is the duty of the clinic to satisfy themselves the marriage is genuine with
Yes.
whatever evidence you
is
have.
very
I
really
remember
true.
one patient, we didn't have anything. Then we, got a insurance policy. So insurance policy where wife was covered as wife by the husband's insurance policy, so that we thought it's a genuine document. Like bank statements, they are usually genuine. Even office statements or salary slips, they are also genuine. So these are the things which can be used. It's not a must that you have to have these.
Along with
Yeah.
along with these bank statements, we can have a self declaration from the couple saying that we are a married couple and this is to the best of our knowledge, something like that we can draft.
We
Like,
actually have a affidavit. Some of the patients.
affidavit from both the
Better to
couple,
have the affidavit.
That affidavit we usually take in case of donor X, that I, wife of
First
this
class
or
nice
like.
affidavit can be good thing.
Parag wants to say something.
Yeah, the first class mindset ability, that can be a very good confirmation, because other anyway you don't have any access to the other portal and all those things. I think in future that will be given, but other number is obviously, Mohini, you can highlight on this. You said that the other is not a proper document. I mean, we cannot rely on, but the other number is being asked in the consent forms also. So we are highlighting the other number. So government is thinking that other has some genuinity, and we always take that copy of the other with writing that this is my other, and I mean self declaration. So that can save in legal point of view, that in good faith, if anything happens, like if we think that this maybe some problem is there, we understand, then we can ask them that to bring a first class magistrate certificate. I think that can solve the issue.
Dr. Parag, your voice is echoing.
Dr. Parag, yeah, mute one device.
You mute one device. Okay, Dr. Sonia wanted to ask one question. Should the counseling be just a written consent, or a video voice consent should be taken? Advocate Advocate Divyanshu is also there with us on today.
Yeah.
So one of you can answer this question. Advocate Mohini, are you there?
Yes, I'm here. Your voice is echoing a bit.
Yeah, should the counseling be just a written consent, or video voice consent should be taken?
Written consent is good enough, but of course, as an additional measure, you can do that.
If I can add something.
Many times by speaking, you might miss out something, and that is a big problem.
So
Written
actually,
consents
can I just intervene?
Yeah.
There is one of our consultants is actually using an app where she switches on that app, and then she talks to the patient, counseling them on every aspect of IVF. And then after that, that whole thing is transcribed. And then that document is signed by the patients, by both the husband and wife, and she also signs in front of them, ki, look, I have explained, this is all written over here. Will that serve as an agreement, or do we have to have a legal agreement, Mohini?
No, that is good enough, ma'am.
That is good enough. Okay.
Yes.
Because
the purpose of consent,
he's putting down
purpose of
every possible
consent,
thing over there. Yeah.
purpose of consent is for any medical procedure is to get the informed consent. So if we are describing everything in the form, and if it is being being explained to the patient in vernacular, and the sign is being taken, that is also good enough, ma'am.
Okay.
Okay, and there's one more question, very relevant, because sometimes, we even take consent on a mail, coming on a mail, because the husband is staying somewhere else. We do that sometimes. Can we discard embryos on the basis of consent received on mail?
I don't think that should be done. No, because we've had a case like that where the husband just wrote an email to the clinic to not discard but withhold the process, but that cannot be taken as a proper withholding of consent under section 22. So there has to be a written.
They suppose a husband sends a mail saying that I don't want the embryo to be transferred, withhold the transfer on a mail. It should not be taken into.
No, he has to sign the consent form. There are forms provided for that.
Many times they are overseas or something.
That is just an intimation, but that's not a final.
So we usually get it witnessed by the wife and one of the husband's family member. Would that be okay?
Yes, that should be okay, ma'am.
But ma'am, the mails and the WhatsApp messages are also taken as proof in the court, no?
Yeah,
So
yeah.
if the patient emails that मैंने बोला कि नहीं करना, but you did go ahead with the transfer, that could land us in the soup, no? That way.
No, but then you have to safeguard yourself by getting the consent form signed by him. If he needs to withhold the consent, then there is a form provided for that also. So you can get it signed and send a soft copy to you, but don't just rely on the email.
Okay.
Yes.
I think
It was a
thank you
great
everyone.
discussion.
Yeah.
We have to close it because we are getting late, so we have to go to the
Yes.
next talk. So our
So
MOC can take over.
yeah.
Thank you,
Thank you everyone.
everybody.
Yeah.
Thank you.
Very
Thank you,
interesting
everyone.
session indeed.
Thank
Yeah.
you so much. Thank you, ma'am.
Thank you, ma'am. That was really indeed needed, and all the discussions that we've had. Later on, we can have the rest of the questions at the end of the session. So now we move to session 2 on Surrogacy Act, and it's my pleasure to invite Dr. Mesh.
Shagun, you're not audible.
I'm not audible. 1 second.
Now you're audible, yes.
Okay. So for the session, we have Dr. Umesh. She is former assistant professor PGI Chandigarh, former fellow University of Washington. And to chair the session, we have with us Dr. Arun Arora. He is ex-HOD GMC Udhampur, visiting professor ICOG, member Quality Assurance Committee UT and of JNK, and external examiner of MBBS exams. And he has contributed to chapters to various books. And we have Dr. Lavleen Kaur Sodhi. She's director cum chief consultant, Dr. Sodhi's Healthcare Multi-Speciality Hospital and IVF Center of Mohali, Punjab. Dr. Neeru Thakral, fellow reproductive endocrinology in ART, diploma gynae endoscopy, and she's director at Thakral Hospital and Fertility Center. And we have Dr. Anupama. She's obstetrician gynecologist, ISR Punjab chairperson, IMA Jalandhar, vice president 2022-24, IFS executive member, Mission Pink Health chairperson Jalandhar. We would like to begin the session now.
Can you see my slides, please?
Yeah.
Yes,
Make
ma'am.
Ma'am, you need to make it full screen.
Yeah, I made it full screen.
No, it's not.
We can't see it full
No,
screen.
it's not full screen.
Maybe there is a delay, but it is full screen in my computer.
स्लाइड शो नहीं है मैम
नहीं मेरे पास स्लाइड शो आ रहा है.
Please share again.
maybe you can
Yeah,
share it one more
I
time.
do this again. But मेरे पास वो Can you see the slides?
Yes, but again, it's half screen.
Again, half screen. No screen.
First make it full screen, then share.
Okay.
Yes, now it is full
Now
screen.
it is. Now
Oh my God.
oh, again it's gone back.
Now, half screen?
Half
Yeah, half
screen.
screen only है.
I think we can see it like that only.
Now?
हाँ मैम
Half screen.
तो कोई बात नहीं.
मैम आप स्लाइड शो स्टार्ट कर लो. आई थिंक वो
यार
ठीक हो
मेरी तरफ
जाएगा.
से तो स्लाइड शो ही है बच्चे.
कोई बात नहीं
अच्छा.
मैम आप शुरू कर दो अब.
हाँ.
Ma'am.
Okay. So, my topic is Surrogacy Act in Practice, and I will take you through the journey of one couple who actually went through this surrogacy procedure in Chandigarh. So, step by step, I will go through and maybe clarify a few points where we are stuck. So this is a 36-year-old lady, 8 years married for 8 years. She visited to us in January 25. Her medical history
Slides
was
are not moving. Your slides are not moving.
Slides are not moving. I don't know, there's something wrong. I don't know what's wrong.
हाँ
Now yes.
now we can see.
अब क्या है, बड़ा है छोटा है?
छोटा है लेकिन देख रहे हैं हम.
देख रहे हैं मैम, कोई बात नहीं.
नहीं, उसमें गड़बड़ हो जाती है. I don't know. Anyway, let me speak from here only. She had carcinoma breast. Lumpectomy and radiotherapy was done in 2017, followed by a patient was on tamoxifen for 5 years. Then again she had a relapse in 24 and she was thus advised fertility preservation, and she underwent IVF center for fertility preservation in March 24 in some other clinic than ours. Actually Dr. Sodi's clinic. So there were 21 oocytes were retrieved and 2 embryos of 8C were cryofrozen on day 3 and 2 blastocysts of grade 4BA and 3BA were cryofrozen on day 5. So I will just briefly summarize few salient points of surrogacy law. See, there are 5 layers of control over this law. The Department of Health and Research is the body which actually decides, but the National Board is the main body which is the policy maker and oversees the whole program. Then there is state and UT board, which oversee the state activities, and appropriate authority is the one with whom you are going to deal directly day to day for supervision, for inspections, for applying and everything. And medical board, appropriate authority, appoints the medical board, and they only refer the patient to medical board, and you are not in direct contact with the medical board. So basic requirements, you all know that the intending couple or woman has to have one of the medical indications which necessitate gestational surrogacy. Nobody can have a surrogacy just by choice. The surrogate is arranged by the intending couple woman. This is the most important and perhaps the most important roadblock in surrogacy currently. And the woman should be willing for altruistic surrogacy, which means legally no charges, expenses, fees, remuneration, or monetary incentive of whatever nature is given except the medical expenses and such other prescribed expenses incurred on surrogate mother, and the insurance cover for the surrogate mother are given to the surrogate mother or her dependents also, or her representative. So as you can't even give money directly, so that is indirectly also to the surrogate. Eligibility of the couples, Indian citizens, this is basically meant for Indian citizens, but persons of Indian origin, couples of Indian origin, the foreigners, they can also avail if they have OCI card. If they don't have OCI card, then they cannot avail. Couples should be married. Unmarried couples, live-in couples, they cannot avail. And the female's age should be between 23 to 50 and male's age should be between 26 to 55 on the day of registration when they apply. Keep adequate margin of 5-6 months as it may take that long. And they should not have any surviving child. And if they have, who is mentally or physically challenged, only then surrogacy can be done. Eligibility of single woman, and similar eligibility criteria are there for single women, but she should be ever married. Unmarried women, never married women cannot have surrogacy. The age should be between 35 to 45. There is a difference in age, and she should provide self eggs. She cannot have donor egg, donor sperm, and surrogate, all three from outside. So she has to have at least one from her own. Then eligibility of surrogate mother, she should be willing. Any willing woman can become a surrogate. But the important part is there should not be any force or coercion. She should be willing for altruistic surrogacy, ever married. Again, unmarried girls cannot be a surrogate. She should have a child of her own. She should be between 25 to 35 years of age on the day of implantation. It, it's not clear on the day of first implantation or second or third because 3 attempts are allowed. So we don't know that part. He has not been a surrogate mother before and does not have 3 failed attempts of surrogacy before. Will not be providing her own gametes. Actually, all these statements are provided in the form of affidavits. They have to be, affidavits have to be submitted for all these statements. So steps to avail surrogacy. The first step is selecting the registered surrogacy clinic. Select the surrogacy clinic. State-specific clearance is given in Chandigarh because these laws sometimes are different because many appropriate authorities give clearance on the base of address of the patient. But in Chandigarh, they give clearance based on the address of the clinic. If they want to get, anybody wants to get a procedure in Chandigarh, then they will give clearance. Direct approach to appropriate authority is possible. Patient doesn't have to go through the clinic. They can apply directly to appropriate authority. Then this couple has to apply on the form for addressed to the state board, form 10 for couple and 10A for the single woman. They have to give an application for the request for surrogacy by the intending couple and affidavit addressed to AA. They have to give application as well as one affidavit. Similar application letter has to be given for the surrogate mother also. Then medical indication and brief history on letterhead by the surrogacy clinic or by patient couple themselves. Basic requirements and eligibility criteria of couple or single woman and surrogate are verified by the appropriate authority. Medical and psychological fitness would be taken and gynae examination is also done by them. The main thing is that medical history, they actually thoroughly verify. They need all types of documents like it's a very common indication, 3 IVF failures. Say they want details of each and IVF, every procedure, evidence of every embryo transfer, the clinic where they were done, what were the result, and they sometimes ask explanations or verification from the clinic where embryo transfers were done also. So this is one thing is it has to. I remember we had one patient of Mullerian agenesis with absent uterus for surrogacy, and even for them everything was there, all certificates were there, but they wanted a fresh MRI to confirm that uterus is absent. So eligibility, I think you are all aware, there can be uterine causes, recurrent implantation failure, recurrent pregnancy loss, or a serious medical condition which may make this woman to carry pregnancy to term safely. Like in this woman, this clause 4 was applicable. This is one form which we have designed for our use, where we just mention the indication and recommend the surrogacy and give to the patient to use for the application to the appropriate authority. But it's not a must, they don't need us. And this is Form 10, which is prescribed by the law, and from 10A, this is for single women, and they have all the details of the couple and the woman for this application. And they have to, submit all the proof like age, birth certificate, or divorce, death, and in case of couple, marriage certificate and age certificate, and the medical condition, the proof of abnormality or medical condition, etc. So then request for surrogacy by intending couple, affidavit addressed to appropriate authority certifies that intending couple women do not have any surviving child. For every statement, you have to give another affidavit. certificate that intending couple woman has a child is mentally or physically challenged or suffers from life-threatening disorder or fatal illness. So the evidence for all this is also required. Reports to prove that at least one gamete shall belong to couple. Single woman report to prove that oocyte will be hers, and records of medical treatment and failures supporting the indication for surrogacy. So this is finally the certificate for medical indication from District Medical Board, which was given to our patient. It's written according to the rule, medical illness that makes it impossible for the woman to carry a pregnancy to viability or pregnancy that is life-threatening. And this is a screening form for surrogate. I will not read through, but this is a general kind of history and examination and investigations form. So then this after this eligibility, the couple and the surrogate, they are referred for medical and psychological fitness. In Chandigarh, the PGI, there is a medical board which has been constituted, and it is constituted by a gynecologist, a psychologist, and a medical specialist. No, psychiatrist, sorry. One from internal medicine, one from psychiatry, and one from obs gynae. So they give their respective fitness, and the surrogate is actually quite closely questioned for their willingness and any question of or pressure. We had one patient where the surrogate was refused at this stage because of the psychological unfitness for surrogacy. After that, the affidavit work with the lawyers start, and agreement. Then there is an agreement between guarantor and surrogate to accept the baby, and there is a affidavit by the intending couple, woman and surrogate. Form 2 is the affidavit. Sorry. The joint affidavit by the intending couple and woman and the surrogate mother stating relation if there is any, mutual and voluntary decision by the surrogate, full consent of the surrogate and her husband, and surrogate will fully support during medical and physical examination, follow treatment plan, and both parties are aware of all the terms and conditions. So this is submitted in the form of an affidavit. Then there is a detailed contract between the two parties. This is the main agreement, Form 2, which is there as part of the Act between the main party. There is an agreement between intending couple or woman with surrogate and witnessed by the consultant. Now the clinic also comes into picture. So here the consultant also signed that this agreement has been signed. So after that, this Form 2, this is the most important document, which is the agreement, and this has been prescribed in the law. So explain this form mainly explains IVF procedure, who are genetic parents and surrogate are screened properly, altruistic surrogate, endometrium will be prepared by medicines, explaining success of such procedure, and pregnancy and insurance coverage is to be borne by the intending couple or woman. Parentage and custody of the child. Order concerning parentage and custody of the child for guarantor is also required. Surrogate has no inheritance right over child, no sex determination done. Surrogate has right to MTP in case of any complications, has not been a surrogate mother before, and will not be providing her own gametes for surrogacy. Another more, and I mean, this is a very comprehensive and complete document. No intercourse after start of medicines for planning pregnancy, no blood transfusion in last 6 months, not disclosing identity. Then intending couple woman should not abandon the child. Abandonment of child is a very serious criminal offense in surrogacy law. and a child born out of surrogacy will be deemed to be a biological child. All the medical and other expenses and condition of the surrogacy with the couple are worked up in the writing, and an appropriately authenticated copy of the agreement has been filed with the clinic. So regarding the medical expenses or the absence of any remuneration, the clinic also has to ensure that this agreement has been signed, and they should keep a copy of such an agreement in their custody. Should a dispute arise, then you can say safely that the agreement states that no financial transaction would be there other than the required expenses. Then there is an agreement between guarantor and surrogate also, and the deponents state that they are fully aware about the responsibility at the nominee to take care of the surrogate child in the event of death or separation of intending couple or wife during and after the procedure as declared by intending couple and wife. The deponents understand role as decision making and fulfilling obligations. The deponents have to be financially, emotionally, and physically capable of taking a child. Most commonly, the parents come forward, and the deponents has no objection to be a nominee. So appropriate insurance, this patient was, life insurance was purchased for 2 lakhs for a period of 2 years, and health insurance was also purchased for 2 lakhs for a period of 3 years. Insurance company recognized this insurance company should be recognized by the insurance regulatory and development authorities. Fortunately, a lot of companies have come up which provide insurance for IVF procedures, surrogates, and donors. Then finally, with all this, they get an eligibility certificate of intending couple and woman and surrogate mother. This is a eligibility certificate for intending couple where everything is written, and then this is for surrogate, again that she is eligible to go for surrogacy, and then they have to go to the court. Order concerning parentage and custody of the child from court of the magistrate of the first class. They have to take, and public notary also is allowed, but I would like to clarify here because in Chandigarh, they still insist on only the first class magistrate court, which shall be the birth certificate after the surrogate child is born, stating that the child born shall be deemed to be the biological legitimate child of applicant under Section 8 of the Surrogacy Act. So this is the court order which is given. And then finally, the essentiality certificate is given by the district district appropriate authority, and then clinic can start their procedure for surrogacy. So this is the essentiality certificate for this couple, and this states that intending couple woman has been under treatment for infertility medical condition as per surrogacy rules, stating medical illness that makes it impossible for the woman to carry a pregnancy to viability or pregnancy that is life-threatening. Couple is required to undergo surrogacy due to medical condition in accordance with the provisions of the terms and conditions of such and such section under surrogacy regulation. So final step is you do final checklist of all the documents, and these have to be signed by the director of surrogacy clinic and consultant in charge. Forms 19 screening of everything is taken, and then the procedure was done, which is and then patient delivered on 13th of August. The interesting part is, which is not covered under the law, we didn't know how to get a birth notification. So birth notification was done online. Copy of the advanced parentage court order was attached, and couple received birth certificate. So no hassles. Birth certificate is easy if you have order of advanced parentage from court. So this is the very long checklist, all the affidavits, all the certificates, all the orders, applications. So we have made a checklist and I sign as director, and one of the consultants under whose care the patient is, they sign this document. So just few important points. This is my last slide. One embryo to be transferred in the uterus of a surrogate mother during one cycle. Only special circumstances up to 3 embryos may be transferred. The number of attempts in surrogacy procedure on the surrogate mother should not be more than 3 times. Surrogate mother can withdraw consent at any time before ET, same like we were discussing in the previous talk. And MTP can be done on surrogate mother's consent as per provisions of MTP Act. Permission of appropriate authority has to be taken before such an MTP, and records are to be kept for 25 years. One thing I forgot to mention, the permission was given for 1 year only. So if the procedure takes longer than 1 year, like some patient conceives and then she aborts after 4-5 months and 1 year is gone, I mean, that's another gray zone where we don't know what to do. And thank you very much for patient listening. And I'm here for any questions.
Thank you, ma'am, for the session. Your presentation has really simplified many important legal provisions and highlighted the real world challenges. So we'll just take any questions.
I think everything has been covered by ma'am. All the points have been covered nicely.
I would like to add
Ma'am,
something
in
to
the
it,
law,
ma'am,
there
if
is
allowed.
previous IVF failure, previous recurrent implantation failure, or previous recurrent abortions. So have they specified it's 2 or 3?
No, they have not specified, but in Chandigarh, take it as 3.
Okay.
Advocate
What?
Divyanshu wanted to say something. Advocate Divyanshu.
Hi, ma'am. Thank you for this opportunity. As ma'am was saying, public notary is allowed. For the order of parentage, it is not allowed. It is strictly first class magistrate, means the judicial magistrate. And that too, the judicial magistrate is allowed. Only his order is valid, not any other order. And whereas ma'am was saying, if 1 year passes on, then in that case, an extension is being taken by us in wherever we are working. So an extension is being taken from the appropriate authority, and then the treatment can go on.
Okay.
Thank you. Thank you for the clarification, because this was out.
And Mr. Divyanshu, in Delhi or NCR, so here what you take, 3 abortions or 2 abortions for the indication?
Ma'am, 2 is fine. 2 is fine. But they should be unexplained. They should be
Ma'am, it
there
is
should be
actually
no
up to the board. It's actually up to the board where it goes.
Yeah.
exactly.
Basically,
Exactly.
it is up to the
It is up to the
board.
board where
Every board will have their own
yes.
decisions.
Usually 2 is being taken care, taken into consideration.
Good evening, madam. I have a question. Whether
Yes, Dr. Mahapatra.
Madam, whether that in that PGT for single embryo transfer, we can do PGT and transfer it, or if you are doing PGT for it, whether we are legally correct or we cannot do it if in a young couple.
Dr. Umesh, ma'am, you can answer.
Yeah, I think there is, whenever law is silent, we can use for the benefit of the patient. So I strongly feel that PGT can be done unless the patient is very young, but usually women who are going for surrogacy are usually not that young, and they do have some medical problem which justifies.
No. That thing is that patient is couple is young only. So we are using their embryo. So PGT embryo, as we know, the euploid embryo will be better success rate. So can we go it if we are doing PGTA, whether we are legally
There is no
correct or
legality.
not?
There is no legality about PGT that way. If indicated medically, you can use it. This is the law states. The
PGT we
statement
can
is
do it,
if
madam?
medically indicated.
Yes, ma'am.
Surrogacy is a definite indication for PGT.
Without
No, madam.
indication, PGT cannot be done, ma'am.
Huh?
That only
Indication
I
तो
am
चाहिए.
asking.
Yeah?
मैम इंडिकेशन तो चाहिए पीजीटी के लिए.
इंडिकेशन तो है ना सरोगेसी, इतनी मुश्किल से परमिशन.
Surrogacy has not been written as the indication of
You can't have
PGT.
failures. Hey, I'm serious. You can't have failures.
PGT can be done for anyone. You don't have to have a special
You have
indication.
to attach a genetic counseling certificate and there need to be a reason for PGTA.
नहीं किसने ऐसा कुछ
PGT can be done for become
Ma'am, they have given only these
because
4
here we are
Dr. Sonia,
advising single
would you
embryo
please
transport.
intervene?
So can we do PGT in a
No,
young
ma'am,
couple?
they have given
Whether
clear
in a routinely
indications
young
of the
couple,
PGT
PGT is
if the
not
age is
advisable.
more than 35,
35,
or there is
yeah.
a male factor,
Who has
or
given
there
who has given this indication?
in the ART
Haryana
law.
state.
Who has given
In ART
this?
law,
In the
ART
prenatal
law,
diagnostic
there
test,
is
no
no.
ma'am, in the prenatal diagnostic जो बुकलेट हमारी अल्ट्रासाउंड के साथ आती है, जो हमने फॉर्म अटैच करना होता है साथ में, उसमें इंडिकेशंस में क्या टिक करना है, उसमें
in the
तो
law,
आपको बताना पड़ेगा ना what is the indication of PGTA. Surrogacy has not been written in that.
they have given recurrent abortions.
Others होगा ना उसमें, others होगा.
Others नहीं है मैम उसमें.
देखो, it is not because surrogacy हो रही है इसीलिए PGT करना है, but PGT I think
Yes,
I mean,
of course.
by and large, we don't recommend it to young couples. But even if a young couple wants to do a PGT, they don't want to go through too many transfers. I don't think you can say, there is no indication for PGT. You are just 30 years old. We will not do PGT. I don't think it is like that.
Even indications in the law itself, they have given.
There is a definite way. मैं section ढूंढ देती हूँ तुम्हें.
मैम PNDT की बुक में लिखा हुआ है.
लिखा हुआ नहीं, ART law में
law में है, ART law में, PNDT मत
ART
बोल,
law में
ART law
5
में है.
indications उन्होंने लिखी हुई
ढूंढती
हैं.
उठा जा भी देती हूँ. I'll just put it up just now.
So this can be discussed later on. We can always put it in the group.
Ma'am, one more question, Jindal ma'am. Like we can do one embryo transfer unless in exceptional circumstances. So previous one surrogacy failure, there we can do two transfer.
हाँ, exceptional तो वही है, embryo अच्छे नहीं है तब कर सकते हो, like that. Exceptional की definition तो नहीं दिया law में. देखो, law never specify medical parts. This is what I understand. They will specify only those parts where legal complications can arise.
And in first cycle, if patient wants, no, I don't want one, I want two transfer only.
No. That's why they have
my
specified
age
one.
My age is 35 and I want.
No, it's not patient's choice. Surrogate scalping is the
So you are transferring one only, na ma'am, in all cases.
So indication for PGT can be single embryo transfer.
नहीं है मैम, ये law में नहीं है. Law में नहीं है.
No.
Law में नहीं है मैम.
We'll have to check this out, I think.
We have to check this out, yeah.
What about Parag? Does he know this? Does he know how many embryos can be transferred? ये embryologist
one है मैडम.
Embryo तो one
embryo तो one है, but PGT है उस embryo के लिए करना है कि नहीं?
नहीं वो कहीं नहीं लिखा होगा. कहीं नहीं लिखा होगा.
PGTA तो तभी होएगा जब when it is indicated. Otherwise you can't do a PGTA just because it's surrogacy.
और ऐसा नहीं लिखा कि जो PNDT में indications है, they are.
Yes.
No. Directly, ma'am, for surrogacy cannot be an indication, but if the surrogacy is happening, then must be the medical indications are there. So if it permits, like the previous failure and any other complications, medical complications, in the ART surrogacy law, that is written that the medically that should be relevant. The medical indication should be there. Now, it goes to the clinicians and the embryologist how it defends that particular thing, that medical indication is there. Of course, for surrogacy, there is a very critical situation. That's why they are going for surrogacy. If any medical condition helps to that, then of course that can be explained.
Correct. So only if there is
states have come forward. States have come forward with different regulation as well. If you would
exactly
see Haryana has come with that CMO needs to give a special permission for PGT in the PGT because of their sex ratio has declined. So they have made a special legislation.
Yes.
They have made special. They have specially ordered that for any PGT testing there should be
a permission
from
prior.
the CMO. Prior permission should be there. Not only it is not up to the discretion of the doctor. It is on the discretion of the CMO and the board. that is there.
But it is only in Haryana.
But
It's only in Haryana.
Yes, it is. It is only in Haryana, ma'am.
Yes.
At present, it is
As the
only in
health
Haryana.
is a state chapter, so the state can take
Yes.
on this kind of thing. And if particular state where you belongs to other cases going on, if they don't have that kind of thing, as in West Bengal, we don't have that kind of thing. Like you have to take permission for PGTA. We are doing in those cases, which is indicated, medically indicated, if clinician is thinking not for the patient is saying, and we will do the PGTA or the.
But
I think we
if
will have
perchance the
to.
patient says, then if a young patient first cycle says, I want a single elective transfer and I want a PGTA, then
we can't do without.
Can't do it.
No. We
If
cannot do
she's
that.
Cannot do
If
it.
she is a previous 3 failure, then we can do. If a previous 3
but
abortion,
the first cycle and age more than 35, then we can do it.
then we can do. Yes, because
Yes.
these
No,
4
yeah.
indications they have given clear cut.
No, here in case of surrogacy, can we do or not?
No.
There is nothing like
There
that
has to
you
be.
cannot do it with surrogacy. It is not like that you cannot do it with surrogacy. If it is indicated, you can do it with surrogacy.
No, madam. Where indication came?
No, just
Where
suppose it's
indication
a case
came?
of RPL
See,
or it's case of
Case of
madam.
unexplained RPL, unexplained RIF, it can be done.
Yeah.
So if there is an indication for PGTA, it is not that
like this patient was also 36 or something. So
Then
She
we can
was
do.
more
Then
than
we
that.
can do. Then we
I
can
think
do.
we need to
So
wind up this
indications.
also.
Indication for PGT remains the same, surrogacy or no surrogacy,
Yeah,
and we really
exactly.
need to wind up because we have another panel also.
Yeah. We have to wind up. Thank you, ma'am. Thank you, Dr. Umesh.
Thank you so much for.
Our MOC can take
Ma'am,
over then.
Yeah. Thank you,
I
everyone.
wanted to add something.
Yeah, Dr. Advocate Devansh. Yeah.
As Madam was asking that how many embryos can be transferred, it is in the first, it is the discretion, it is the one embryo transfer, and after that, it is the discretion of the doctor. However, up to 3, that is completely on the doctor how many embryos that she wants to transfer after that.
Yeah.
Yeah,
But
correct.
First cycle, one.
First cycle is one only.
One only, yes.
She can transfer 2 in first if she has a medically valid reason for it. Then she can definitely.
See, it is not like that the first cycle only one only. There is nowhere it is written that for the first cycle you have to
There is
transfer
no,
one. It is written that you have to transfer one. If any indication is there, you can go up to 3, but that should be substituted by the clinician and the
up to 3.
embryologist. Suppose the embryo is not the good quality and you are not sure about that particular viability, then you can go ahead with the 2 embryo transfer, or 3 is very rare, but 2 embryo transfer can be done.
True.
I agree with Dr. Parag because, Advocate Divyanshu, this situation happens that the embryos are not good quality and you're not confident about transferring one embryo in the surrogate. So in such situation, I think in the first cycle also 2 embryos can be transferred. It should be the discretion of the embryologist and the clinician.
No, usually in surrogacy, it is advised by the appropriate authority and by the boards in itself that only one should be transferred. But it is again, if a medical reason is there, then doctor can have it in writing and transfer up to 3.
Yeah.
Thank you, everyone. I think we should move ahead as we are running short of time. So let's move to the grand panel discussion, navigating the regulatory framework of ART practice in India. I would like to invite a moderator, Dr. Aarti Luthra, Director and Chief Consultant, Luthra Maternity and Infertility Center, Dehradun, Dr. Mandeep Kaur, Consultant Staff Fertility, Jalandhar. And to chair the session, we have with us Dr. Sonia Malik, Member IFS, Dr. Parag Nandi, IVF Lab Director, Clinical Embryologist, Cardinal Infertility, Kolkata, and Dr. Syed Sajjad. He is MD, MedAge Infertility Center and Gynae Solutions, Srinagar, JNK. And on the panel, we have with us Dr. Meenakshi Dua. She's Scientific Director, ART Fertility Clinics, Gurgaon. Dr. Ritu Nanda, Director and HOD of ART Unit, Ritu Nanda Gynec and Fertility Center, Jalandhar. Dr. Snober Gulshan, Dr. Geetu Dr. Nirmal Bhasin, Director and Clinical Embryologist, Janni Fertility Center. Dr. Meenu Vaish, Director and Consultant, Meher Hospital, Dehradun. Dr. Shanujit Kaur, Associate Director, Department of Infertility and Obs-Gynae, Cloud9, Chandigarh. Dr. Tanu Verma, Consultant, Obs-Gynae, Fertility Specialist, Gynae and Lab Surgeon at Asta Multi-Speciality Hospital and IVF Center, Mandi. And we have with us Advocate Divyanshu. He specializes in healthcare laws, ART and surrogacy regulation. Over to you.
A very good evening to all respected seniors, Dr. Sonia Malik, Dr. Jindal, and delegates. I would like to welcome you all to this highly relevant panel discussion on navigating the regulatory framework of ART practices in India, practical challenges. Although a lot of our doubts have been cleared by the previous discussions, especially by Umesh ma'am's talk on surrogacy. And as we all know that by the implementation of ART and Surrogacy Act, assisted reproduction in India has entered a new era of accountability, transparency, and ethical practice. With these regulations, we have strengthened patient safety and standardized care, but at the same time, we have come across several practical challenges while doing these cases. So I would like to invite all the experts on the panel and panelists to present their experience and their practical solutions to our case scenarios. So Dr. Mandeep, we'll be starting with the first case scenario. We can have the first slide for the case scenario, Dr. Mandeep. Yeah.
Yeah. So, a 58-year-old lady whose son has passed away, she in an accident wishes to undergo IVF with donor eggs, and she's bought an undertaking from the court stating that if she dies, she is herself responsible. And she also says that producing children at any age is her fundamental right, and it's her personal issue, and government has no role in it. And she also quotes the case of the famous singer Sidhu Moosewala, whose mother had a son at the age of 58 and is fine. She had no life-threatening problems. And she also threatens to sue the doctor if she refuses to pursue her case. And she persistently insists that the baby should be a male.
In
So,
fact, yeah, all of us must be experienced this kind of case in past 2 years. I have seen requests from 3 mothers where the young son, he died in an accident, and the lady at the age of 60, she's walking in into the clinic that I am very keen to go for donor IVF. So I would like to ask one of the experts, Dr. Meenu is here. How would you like to proceed for such case, Dr. Meenu Vaish?
Thank you, Dr. Aarti and Dr. Manpreet, for giving me opportunity to discuss this case. This is a usual case we find in our clinic. What happens? Most of the women come when the young boy died, and they want to have another child. In this particular case, according to the rules and regulation, according to the ART Act and ART Regulation 2022, the maximum age which women can undergo ART procedure is 50 years. Here we can see that the age of the woman is 58 years. So she is not eligible for ART procedures, but she has got the undertaking. She has got the statement from the court. But the bringing the statement from the court is not the right way. We cannot do unethical thing while the patient is getting the undertaking. We have to go by the ART rules and regulation. So we can refuse this procedure to us, and this court statement cannot override the legal regularities, ART rules and law statutory. So we have to tell them clearly that you are not eligible. And then she is saying it is her fundamental right. No, here comes the question that no doubt it is a fundamental right, but there is a certain restriction to the fundamental right also.
So, madam, I would like to ask that there are a set of patients who
Right.
went to the court of law and they took permissions also. So the court allowed them that yes, considering your case, we can allow you. So what is the doctor supposed to do? So recently I had a court case against me. So there was this lady who was 52 years. She came to me. I refused. And so she put a case against the government of India, government of Punjab, the district appropriate authority of Hoshiarpur, and my name also included in the list of people against whom she. So I asked the lawyer why you have put my name, because I just practiced law. So he says that you also have to be party to it, because once the permissions come, then you'll only handle the case. So it is unnecessary hassle for us also, because we are stuck in between the patients demanding, and the number of patients coming for these kind of issues is not less. Probably
Very true.
some 10 to 15 patients every month. So it's a big problem. And we recently got a letter from our appropriate authority that if you get a letter from the High Court stating that you can, do this, still you have to take permission
Say
from us.
no. Yeah. It is very important. It's a very important thing that Dr. Manpreet, you are talking about. Very frequently we get this case, but we can protect ourselves only we stick to the law. Only we can protect ourselves in the court. Even the court says and the patient can file complaint against us, but we can protect ourselves if we stick to the law, if we take the consent documentation, everything, and we stick to the law.
Yeah.
Only then we protect
So
ourselves. Even the court is giving the
anybody
permission.
else has any other
Yeah, Dr. Mandeep here, Dr. Shanujit. Dr. Mandeep, know what? We have lawyers who are blatantly telling us कि हम लोग आपको whatever age you want the patient to be. I just had one yesterday coming to my office telling me that we can take permissions for surrogacy for any age. So I was also shocked कि भाई what is he telling me? But my question in fact is, if the court is saying that you do if the court is saying that you have to do, I think we have to do that. Even I am in a dilemma. If I had to refuse this patient, I would refuse on the last point. Gender selection is a sin, is a crime in the country. So even if she says court, I would refuse her on the section that she wants a male child.
So here, can I say something?
Yeah.
Yes. So here it is written that she has brought an undertaking from the court stating that if she dies, she is herself responsible. Undertaking is of no use. Only a court order would maybe give us something to think about it, whether we should take up the case or not, because the doctor still has the right to refuse.
Yeah.
So that's in the
There is a
constitution.
certain restriction.
Yes.
We have to
Yes.
be in the best
Yes.
interest of our patient. Maternal
And
health matters a
then
lot.
medical fitness. The patient has to take medical fitness from the required authorities. Only then, maybe, if the doctor feels that yes, they can go ahead, you can go, but only with a court order and not an undertaking.
And even after the court order, you can refuse that I don't want to take
Yes,
this
that is
case.
your choice. Yes,
There
you
will
can
be no
refuse.
legal offense against us.
No, it's in the constitution that a doctor can refuse.
So,
Doctor
ma'am, what about our plea to the lawmakers to amend this, that if the patient is medically fit, like for example, somebody who has just crossed 50 years, like for example, 51 years, 52 years, who's working, like we are also of that age, we don't feel that we are that unfit,
Those
so
permissions are being
No end.
received. Mil
Then
rahi
there
hain
will be
permissions.
no end.
Manpreet,
I think 50 years is a good enough age. The 50 years
No, but
ceiling is good enough.
Shanu, some permissions are being granted and cases are being done successfully.
No,
ऐसा नहीं है, वो medically fit होने चाहिए, and 52 अगर ठीक लग रहा है तो there are cases which have. I think Jindal ma'am also knows about it.
no, that was an exceptional case.
Yes.
I just want to ask the whole panel and the whole experts who are sitting. Besides law, what was your practice before the law came? Were you doing IVF indiscriminately at all ages?
No, ma'am, we were looking at medical fitness.
No.
We were doing.
Why
We were
not?
doing.
Why not? Why this 50 years of age has come? The basic
because of
reason
the
is,
safety.
see, what is the ultimate aim of IVF? A healthy live on term baby, right?
Yes.
So the baby you are trying to bring to the world, you have to think of the welfare of that baby. The later is the age of mother, 58, like in this case. What would be the age of mother when the child is 20 years old?
That is the thing.
And you have to see the
78.
So it's
parental
like about
bereavement.
producing orphans,
Parental
basically.
bereavement is the worst kind of complication which these children of older mothers face. So you have to think from that point.
Yes,
Mothers,
ma'am.
yes, definitely
But the
very
point
important.
is that we still
Nobody
need
will
to
do a nobody will
we
do an IVF for a today. I also got a patient, 58 years, same story, but she had hypertension, and because she was mourning the death of her son, she was not even taking her antihypertensives. Her BP was 190. She was
and
obese.
that is the only point when we become so incapacitated because the
So,
patient comes
so
and
it's
mourns,
so
so
it's
we
your
become
counseling.
carried away
No,
with
no, no,
this.
no. Don't get carried away.
No,
This
Don't
is
yes.
get
your
carried
counseling.
away.
See, the family has undergone a shock already. Don't give another shock.
Yes, true.
Yeah, Dr. Mandeep,
Or
lot.
ma'am, or ma'am,
Let us
kabhi
ask
kabhi
the
these
lawyer.
patients,
Let's
they
take
come
this.
with fake young age Aadhaar cards. And as wise doctors, we can always look at them, and then when you talk to them, they break down, and then they tell you the realities. When you counsel them well, you know, it's not just about losing a child. Tomorrow, that man will be losing a wife as well during all this
Exactly.
procedure.
This
That's
is
how
what.
I counsel.
Absolutely.
And we have all the right to refuse, and nobody has can just push us to, asking for male children.
So
Let
don't
us,
go by.
let us,
Yeah,
excuse
initially
me.
when we were practicing, there a lot of sex determination also. We used to say no. We
Even
need to
we said
we
no
need to
today,
know
ma'am.
what is right
No
for
means
our patient
no.
and
Yeah,
what is
even
ethically
today we
right.
say very boldly no.
No.
Patient
Yeah.
can walk
Uh,
away and go
so
wherever he
so
wants.
one
Ethics
should
are
go.
ethics.
Yeah, one should go by the spirit of the law.
Yes.
So
And
Now,
we
spirit of the
practice
law is
that.
this.
Can
Ma'am,
I,
if
can
we
I, can I
ma'am, if we
interject
practice that, people cannot push us into it.
Yeah.
That's
1 minute?
for sure.
ma'am,
Let
you're
us take
totally
let
right.
us take the alternative now, the alternate view. We have this lawyer sitting in front of us. Divanshu, are you going to defend a case who comes to you at age 58 and she wants a court order to say that she should be allowed to have a child? Will you defend that case or will you not take that case? As a lawyer, you tell. Actually, it is the lawyers who actually defend such cases and they get the court order and then we have to do it.
Yeah,
So,
exactly,
what is
ma'am.
your
Ma'am,
take on that as a lawyer?
ma'am, if the treating doctor finds the
No, no,
lady
no, 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 no.
to
I'm not
be
talking about. Patient is
no,
58.
Before
no,
the
She
We will
hasn't
ma'am,
been
follow
to
ma'am,
the
a
rule.
doctor. She
We will
I
hasn't
will
been
follow
do
to
the
a
it.
law.
doctor.
I will do it.
You will do
Ma'am,
it.
I will do
So
it.
there it is. So
I will
there.
do it in this scenario once I have a backing,
Uh,
medical backing by you stating
uh,
that she is medically fit to carry the child.
uh.
Then only I'll
The
take the
child
matter.
and then carry the child till up till age 20, or just carry the child and give birth to the child. That's it. How will you take
Ma'am,
what? How will you answer Dr. Jindal's question? What happens to this child when he's 20 years old? The mother
ma'am,
is 78.
Ma'am,
correct.
That is
Ma'am,
what we
Indian
want
And
to.
women
that
are
too,
That is what we want to
Indian
ask the
women are
lawyers.
dying at
and
70,
wishfully
65.
78, she will be there.
Yeah, she will be there.
No,
Okay,
no, no, 78, you don't know whether she would be there or not.
correct. So
So,
therefore, she
You
could be dead today. She
usually
may be having a
usually
silent angina for all you know. How do we know whether she has silent angina or not?
Ma'am, probably
mm,
it's not his prerogative to decide. He's
Who?
saying that if a clinician writes and sends,
I'm saying, Neeti, I'm saying
ma'am,
the patient has not been to a clinician. The patient is coming directly to the lawyer and saying, I am 58 and I want to have a child. I want a medical, I want
ma'am,
a
then I'll not apply.
defend.
Then I will
we
not
also
apply, ma'am, because
That's
I
what I'm
need
saying.
a medical backing in the court.
no,
To
ma'am, we
prove my
can't be
case,
seen
I need a medical
conniving with the
backing.
lawyers and doing this. We can't be seen conniving with the lawyers and raising the age for them.
That's
So we
exactly
can be
what it is.
backing the lawyers who are fighting cases. Oh, yeah, really.
Uh, So
Ma'am, if
therefore,
she is fine,
uh,
if she is fine, if she is medically fit,
uh,
then it is then it is a good case. If she is not fit at all, then it should not be recommended in the first place, because the court will look at the recommendation of a doctor. The doctor finds her fit on the parameters that she can carry the pregnancy to its viability. So in that case only the court, we go to the court. If a doctor writes, if a doctor will not write that she is not fit for pregnancy, the court will in the first place throw away the file, say तुम्हारा नहीं
And
बनता है भाई, तुम जाओ.
Well,
and
let me
another thing is that we used to feel very disgraceful when people were doing IVF at 72.
Yeah.
So those extreme cases are very bad cases. So we are just talking of near borderline cases, like just 51. She could not do just because she was fit, but she could not do just because the law said. I mean, we're not talking of those extreme cases when we felt disgraceful that why doctors are doing, at this age. It's a disgrace to the IVF world. We're not talking of those bad extreme cases. We are just talking of the borderline cases where
That is
they are
all
fit.
right. That is different.
Ma'am,
But what we are saying is
with your permission,
sorry.
sorry, ma'am, please go ahead.
No, you said with my permission. You have my permission.
Ma'am,
Bol, beta, bol. Yes.
ma'am, the court will not permit at the age of 58 whatsoever. That is one thing. Because when I'm going to the court does not only look at the act, it goes into when I file a petition, I file a select committee report by the committee that had come into the before this bill. So it clearly states what is the reason for the age capping for a male, and what is the reason for a age capping for a female. So the court is not going to entertain this. The court is usually giving permission till 52, 53, at max 53, not
So,
above that.
yeah,
So this
ma'am.
58
So that means if a
is a
patient at
far-fetched.
50 plus comes to us, we should promote her to go to the court if she is medical fit.
Ma'am,
It's your choice.
if she's medically fit, then it
Your
is
choice.
then it is her
It's your
discretion.
choice.
It is her discretion.
You
If
can
she
give
wants to
her
go,
options.
if she's medically fit,
No, is
This
it
is
okay to give her
one way you
options?
can
No,
go
no,
about
Okay.
it's okay.
Is
if
it
you are
legal
so
to give her?
desperate.
I have given this option to one of the patients yesterday only.
Okay.
Yeah,
We don't give. Till now, I am not giving this option. I say no.
absolutely fit, and she
I
is like
agree with you.
48, but the husband is 56. Husband is
Yeah.
56.
That is a different scenario. 37 by 56 husband.
They're also not allowed, right?
Yeah.
I told them to go to court.
So, yeah.
So Naid, let me just put it a little differently. Why then is this age of the surrogate fixed at 40, 35 to 40?
35.
उसके beyond नहीं जा सकते 35. Why is it fixed? Why can't they say that the age of the surrogate can also be 50? There is a reason, isn't it? That after that, the complications to the mother increase. So then, why should we defend this thing that if the patient is above 50, we should still try to help her. We shouldn't, because it's risky for her.
That is what I am telling. We don't have to counsel it and go to the court.
So the take-home message is that we should just refuse.
Yes.
What
Go on
Mandeep
to
is
the
saying
next
is
case.
that
Go on
there
to the
could
next
be,
case.
there
So,
could be a
The next
51
Dr.
year
Aarti?
old. There
Yeah.
could be a 51
8
year old
बज गए
who
8
could be
बजने
fitter
वाले हैं
than
just
a
5
45 year
minutes
old.
yeah.
We
So
go
there
to
could be
another case,
51
but
year
Sonia
old
ma'am,
fitter than
I
45.
would like to add a point that it was really in the news that how come a 58-year-old lady got ART done with donor eggs in India, and whether she got it done here or she traveled abroad. There were a lot of question marks on Musewala's mom's pregnancy also. So we have to explain it to the patients that it is not legally correct, and they are still giving details about this. So it's not right. And ideally, there should be some punishment, or the doctor has to be explained why did they do that, so that in every state, these kind of older patients, they don't come and trouble ART specialists. And lot of times what happens, they have one or two daughters coming along, because if the son,
Yes.
the daughters are 28, 30 years with a small baby. So how I convince them, I tell the daughter, see, you can lose your mother now if she gets pregnant at 58 or 60. So rather you plan a baby and bring happiness to the family rather than putting your mother at risk. Now we'll come to the second case again, which we are seeing in the news. Every day there is, discussion on it. A young couple got IVF done, and they were blessed with twin daughters. And then later, when they got the genetic testing done, the babies didn't match to the couple. Now they got the procedure done at a different IVF center and delivered at another hospital. This couple is posting everywhere into social media. There are every day we are seeing the reels that how do they love these two babies. So what is the logical way of solving such issues so that the doctors, the ART clinics, they don't get a bad publicity? I would like the experts only to comment on this, I believe, because this is just a controversy, not a management.
So you know
Yeah.
that
So,
we have to
okay.
start from the time we are creating. I think we should start with the embryologist answering this question first.
Yes, I can.
All right, who answers this question? And you can answer this question. She was saying the experts have to answer, so therefore I was one of the
Okay, sorry, ma'am. Sorry. Yes,
Parag was
please.
one of the experts, so I was therefore thinking कि पहले embryologist बोल दे फिर मैं बोल देती हूँ.
ठीक है
That's
मैम.
what I. चलो, Parag, can you just answer this? How you're going to be vigilant when you're making the embryos? Is he there? He's not there. All right. So we know that we have to do witnessing when the embryos are being created, and that is very, very important. If you don't have the witnessing system in your laboratory, then a physical witnessing is essential. There should be a second person always standing who witnesses and says that all the procedures at
Yes,
every
ma'am.
step is being done
Yes,
properly.
yes.
That is what it is.
Parag
And
has
so
come.
you Dr. Parag, can you just
No.
comment on this? Because only she asked the experts to make comments on it. Okay.
So it's like a very difficult situation for
Yeah.
them. But legally, what we need to do that the first is first, like the documentation of the clinic should be perfectly okay, and the witnessing system, double witnessing system, that should have been done. Every clinic do not have a digital double witnessing system, but the physical double witnessing that many of the clinics they follow. But you cannot prove if it goes to court. The thing is the paper will talk. The thing is, like, it is not a matter of talking publicly and all these things. It's a matter of now I think the law and order, and the papers will talk that whether the permission was been taken for properly. Any video documentation is not mandatory, but the documentation was being done or not, that is the thing. But if you ask me, for our practice, embryologists should be very careful about this kind of gamete mixing. This is I would say, if it really happened, that would be a I would say the black swan event kind of thing, like that it has mixed. But if it has not mixed, then the paperwork again will come to the picture. If they have double witnessing system, digital double witnessing system, they can prove that with that particular, with the time and date stamping, everything is there. So they can prove that thing, whether that care was being taken properly or not. So that is the thing. But the physical double witnessing is a must if you have a digital witnessing double witnessing system. Like surgeon 1, 2, 3, like kind of the embryology should have that kind of a backup, just
Yeah, so
in
here
case it happens.
as an embryologist, even I would like to share an experience. We had
Yes,
a
ma'am.
patient with the same name, and when we took out the straw,
Yes,
during when the fume, sometimes you cannot very clearly read it, right? So I
correct.
happened to thaw the straw of patient A with the name A, and husband's name was B, for example, and the other was A and C. So the moment the thawing was done, I generally we have a witness with us, a staff or another doctor. But after thawing, I again checked the straw properly, and those embryos were refrozen, and again the straw was taken out. So this error can happen, but we have to be
Absolutely.
extra vigilant. That is one. But in specifically this case, what I feel that it could be an error, it could be a mistake, but we should know the whole story. It could be something else. They could, because there are speculations coming up that it was an embryo donation case and they already have two daughters. So we don't know the actual story, which will maybe later come up later. So
Yes.
yeah.
So there was another case which was reported from Delhi. Again, in that case, the DNA was not matching. But there, what happened was that the semen sample was not collected. There were two people inside the semen collection room, and the husband passed on the collected semen to a man
Swapping.
who was, yeah,
Yes.
who was actually not supposed to be in the clinic. And then the sample was handed over to a doctor, again, who was not a part of the system, but was present at the time of this whole thing, that the whole procedure. And she was standing there. She was not a part of that clinic, and she was yet standing inside. And then, on top of that, the name of the embryologist was missing from all the files, and nobody knew who the embryologist was. So that kind of a shady thing happened,
This
and
is
therefore,
planned. Yes, this is planned.
yeah, this was planned. And therefore, therefore, a huge fine or whatever was clamped on the clinic, and that was a very bad case also.
Sonia,
So I think the only thing is that you have to be extremely vigilant, and you have to be very careful at each step that these things do not happen. Especially, when the semen collection is taking place, we need to be more vigilant, I think.
Sonia, my question is, if something like that happens, then who is responsible? Embryologist or clinician?
The team.
The whole
The,
team will be responsible. उस केस में
the
तो embryologist और
problem
team
with this
First,
case
first
is
the First, it would be asked to the director if the director is available. If
Yes,
director can
yes.
confirm that the SOP was there, I have given this kind of, I mean, the proper measure we take always, and we have the standing SOP, and that should not happen. Then it will go to the embryologist, and embryologist has to explain that thing, that whether he has done or by instruction, and if instruction, then any proof. So this is kind of a thing.
And
We always do
another,
before embryo transfer, before for this kind of semen swapping, we generally get a, consent from the patient. It is an extra, like this is my biologically my semen, and I am confirming, and this
yes,
is the
Yes.
we are doing the same. Yes.
and the clinic is not responsible if anything any changes, any other semen or sperm I am giving in place of mine. So this kind of thing will safeguard you in future if anything happens like this intentional semen swapping without informing to the embryologist or the clinic.
Yeah.
But
We'll
ma'am,
ma'am.
one thing can I ask? Because there's something which sometimes is very difficult. Once, one of our patients, she got a boyfriend to give the semen sample, when the procedure is going on. And luckily, one
Yes.
of the staff, she said, ma'am, this is not the same man who comes every day with her, but sometimes it can be missed also. This is really dangerous.
That
It
is
is
the
dangerous.
SOP you have to create once the patient comes for the semen sampling. Some witness
So
should be there to check the same person. Yeah.
Aadhaar, husband's identification,
On the
everything now
day
we
of
have become
collection, yeah.
on the day of registration.
On the day of registration as well as on the day when you are doing your
Yes, yes,
procedure.
whether it's the same person or
And we
not.
have taken marriage certificate, everything. But suppose everybody is busy and that
Yeah,
person
you cannot at
You
times.
have to keep one person there to keep a
Yes,
check on
yes.
the.
I
That was
think
our good luck. The girls identified कि मैम ये तो कोई और आदमी है. So
I think we should, the way we are asked to post a picture, a small picture when they're giving of the person providing the sample. This will be the easier way, and we
Or
should
you
take.
install a camera outside the semen collection room, then you have a
yes.
proof that this person went inside.
But
The
they,
only flaw is if the person has brought that in the pocket.
otherwise, we tell them to get a picture because it's a proper procedure. We are asked to provide our pictures for passport for different things. So they should also provide a picture while giving a sample. I think we can start doing that. We'll quickly come to the next case because the time is also
I
running.
just wanted to add something, ma'am.
Yes, yeah, sure, Dr. Anupma. Yeah.
Ma'am, the problem with the previous scenario is not that everything has gone haywire. The problem is that the DNA of those two kids does
Is
not
not.
match in the first place. That is
Yes.
the biggest problem here, because it is barred by the law that two, embryo, even in the case of embryo donation, it cannot be that two embryos of
Different.
four people, different people as is being inserted.
No mixing allowed.
No,
No
no, there is no
mixing.
So
mixing. No, no, no. The kids don't match with the
Each
parents.
other also. No, they
Each
don't
other
match
we
they
with
do
don't
each
not
know.
other
match with each
also.
other as
Oh,
well.
oh,
They
अच्छा.
don't match with each
That
other
is the
also.
ये
biggest
नहीं
issue.
पता कि each other भी है.
Each other भी नहीं match करते.
हाँ,
अरे
They
फिर
do not
तो
match with each
फिर
other
तो
as well.
फिर तो छोड़ो.
But
That is the biggest
ma'am,
issue of this
another
matter.
logical way of handling this is going through court of law rather than going to the
Social media.
to
Yes,
the
yes.
social media. So if they want to pursue this case, this is not the right way. They should go through a court case rather
But
than
they say कि no FIR is being recorded. That is why they have come to social media.
This
We
is
don't
to
know the.
create pressure.
We don't know
This
the
is to
true
create
story.
We
pressure.
don't know the true story.
Okay, let us come to scenario 3 then. We don't know then.
don't know the story.
This is also a very pertinent problem nowadays.
How
A
many
couple,
cases do we have?
Ma'am, we
ma'am,
have 9 cases, but we'll stop when you say.
whenever you will tell us, ma'am. Maybe this is the last one because it is 8:05.
Yeah, it is
Yeah.
already.
I
Yeah.
think they have prepared very good cases. Let's, if they are ready, we can go on for, let's say, 5, 10
Till 10 o'clock. Till 10 o'clock.
Maybe 10 o'clock
Fine.
नहीं, ma'am.
Maybe we can have one more
Okay,
webinar,
we'll
Dr.
set a
Niti.
timer. We'll set a timer, 5 minutes for one case, and then we'll
Yeah.
go to the
Yeah.
next.
10,
Yeah.
15 minutes
All
दे
right.
सकते हैं मैम. हमने लेट स्टार्ट किया है इनका पैनल.
5 मिनट स्टार्ट किया लेट. चल कोई बात नहीं. आरती चल.
Yes, ma'am. A couple needs donor eggs and there are no eggs available as all the donors back out for loss of wages during the process. And the criteria of altruism makes things very difficult. She is not willing in a case of zero financial compensation. The couple have a known donor who's a sister with a Norwegian passport and she's 38 years. So, is this once in a lifetime donation, mandatory insurance, altruism, pushing patients to unregulated channels? This is a very, very significant issue.
क्वेश्चन किसको पूछ रही है?
So,
मैम इस
as
प्रॉब्लम को
they
कैसे सॉल्व करें? पहला
Dr.
क्वेश्चन ये कि नॉर्वेगियन पासपोर्ट होल्डर डोनर बन सकता है कि
or
नहीं?
Yes.
38
No.
ईयर का पास जो नॉर्वेगियन पासपोर्ट
No.
होल्डर है वो डोनर
No.
बन
No.
सकता है
Yes.
कि नहीं?
No.
Age.
Norwegian maybe yes, but age no.
Yes. Age no.
See,
Yes,
even
only the age thing is
Age is
Otherwise, she can be a
age and
donor.
other things.
Yes.
Yes.
Yeah.
so
So,
this
ma'am,
question
Also
passed.
not
zero
advise them to
zero
get the
financial
children.
compensation to the donor.
but
Doesn't
loss of
matter
wages
age.
can be
Law
paid.
says
But
35, so we cannot do it.
yeah. Because she is not getting donor. The patient is this particular couple is not getting donor just because of the altruism, because there is no financial gain to the donor. So,
So,
so in this particular case, she cannot. She have to wait for the donor, eligible donor, and she have to rely on the ART bank. She cannot take from her Norwegian sister.
She
So, ma'am,
can.
we are talking, we are talking.
compensation for daily wages is
That
allowed.
is allowed. That is
That
allowed.
is allowed.
See,
That is allowed. The medical expenses are allowed. The
see,
daily wage loss is allowed.
Of loss
see,
allowed.
all banks are definitely charging, a good amount of money for the donors. This is just a hypothetical, situation. We are saying the zero finances. It's not zero funds finances. Whenever we are getting from a bank, we are definitely paying the bank.
And the bank is paying to the donor too.
Yeah, the
Then
bank
let
is
us
paying
go
the
to a
donor
known
as well.
donor.
So,
So let
Malvika,
us
you can't say that, because of loss of wages, there's no loss of wages. They are getting money.
Listen, here I would like to tell you the way we work. We also have a bank, and it's not a bank just for our center. We have a bank which caters to other centers also. So we charge only for the registration and verification. And if we are doing the investigations and insurance. So if insurance the patient is doing, we don't charge. If investigation the clinic is doing, we don't charge. So loss of wages to the donor is all a different scenario altogether, which the bank doesn't take. So that is between
This
the
is the
patient.
gray
That
area.
is the gray zone. Yes,
Yes.
yes. So if, of course, the donor is being paid something, so she signs vouchers for per day visit, travel,
So,
nutrition, whatever.
so
But
ma'am, one more thing.
and
Like
they're not being paid money, that we have to only for the registration and verification we charge.
like when we were following the ICMR guidelines 2005, we were refusing known sperm donors. Like we were refusing कि नहीं हम family member नहीं ले सकते. Now, according to this law, we can take a known.
Actually, if we logically think about it, that was a better proposition because there would have been no, emotional bonding or
Legal
blackmailing
conflicts.
or legal conflicts
So in
related
this
to
particular
relationship.
case, the law has become more lax, I would say,
Yes,
than
yes, it
what
is
it was
more.
before.
Yes, yes, it
We've
is
been given more liberty in
Yeah.
terms of using known donors
Known donors, yes.
than
Known,
what it was
unknown.
before.
This is the only place which I find, like, before law, the as Dr. Jindal was saying at that time, that how we used to practice at that time, before law. So this is the only scenario which I find, and
not good.
maximum people are finding, like, this is a different scenario, and it can lead to many ethical and family problem and all these things.
Correct.
But things are now abide by law. We cannot say no to anyone, if they are bringing their one, because the anonymity is not, nothing is like that, and we cannot hide that thing also. So we have to go ahead. Otherwise, I am fully with Dr. Jindal, as she was saying, that we have to go with the ethics before law. Ethics cannot change, law can change. So that is
We
the
have
thing,
to go
but
by
here we
law
cannot do.
because law is ethics.
Yes,
And I think
ethical law.
this proposition has been made to promote the altruistic donation, so that you should find a girl from your family rather than making it a commercial thing. So that is why the law is promoting that within the family.
Correct,
Okay,
correct,
scenario
correct.
4.
With small families, where are we going to find from the same family in future?
And exploitation within the family also is getting more prevalent now.
Claiming the child later that ये तो मेरा बच्चा है, आपका है ही नहीं.
But we are making all those affidavits, na, Mandeep, from the,
But
we
still,
are getting them.
even telling the child that, okay,
verbal
even
abuse.
telling the child later when the child grows up, or
Attracting the
just
child
within
towards
the
your side.
family,
Emotional trauma.
exposing, exposing.
That's really sad. That is
Psychological impact of all this. Okay, let us go to scenario 4, Dr. Arti.
Yeah. A married couple, this is a similar case what Dr. Neeti was mentioning. A married couple.
The same patient
48
as
and 56, yeah.
Same
That is a routine thing again in Punjab. Young girl married to an NRI who is 56.
Absolutely. So, as per the law, the husband cannot take treatment, but he claims that the risk of childbearing is for the wife and he has no role in such a case. And he's threatening the doctor for medical legal implications in case of refusal. So, how would you tackle this situation, Dr. Anupama?
Go to the court and take the permission. That is what I can say. I cannot be beyond ART law.
Divyanshu will help.
You have to ask them to go and take permission from the
Yeah,
court.
that is the only way out.
I second.
By law, we
I
cannot.
second what Dr. Anupama said. Go to the court and take the permission, and then.
On a lighter note, it's a joke, please. You can tell her to take donor sperms from a young.
No, you cannot go ahead with donor sperms too.
नहीं मजाक.
नहीं वैसे because divorce लेके करे.
Ma'am, he will not agree
ma'am, you
for
can-
donor sperms.
Divorce लेके कर सकती है.
What we started doing was
divorce the man.
What we
Divorce
started
the
doing
man.
was that we started counseling them that the child has a higher risk of having mental diseases like schizophrenia. So it's not healthy to take sperms of a male who's of advanced paternal age.
So take a divorce.
Yeah, there are
And then come with donor sperms.
No, there are articles.
You cannot break the family.
True. Mandeep, that is true. There's a lot of evidence. There is a lot of evidence that men at above 55 years of age, if they're going to father a child, they are going to
The
have
child
more
is having a
defects,
higher risk of having
more genetic
schizophrenia.
defects in those
Genetical
babies.
problem also.
Lots
Autism.
of evidence.
Yeah,
Autism.
and but okay, in this case, I'd like to add that if the couple is threatening medical legal implication, on the other hand, इसमें हमारा we have no medical legal implication. The law is on our side.
Yes.
So it is for them to take the permission and get the case done.
Only time gets wasted. No, ma'am, they'll keep on sitting and cracking your head that,
No, but
you know,
you should not let it. You should have a thick skin now.
Okay, scenario 5, a widow comes forward for treatment, planning to become a single mother. And during the counseling, she tells the psychologist that she has a lesbian partner. So the doctor is informed about it, but all the paperwork is up to the mark. So now law above ethics or ethics above law?
Law says she can go
Is the criteria and she fulfills the law.
She fulfills the law.
Yeah.
As long
Because
as
she
she's
is
using her own eggs
widow.
and we are going for donor sperm, a single woman, she might be a lesbian or whatsoever, as long as she's using her own eggs, I think she can go ahead.
And
You
the
know?
paperwork is up to the mark.
Absolutely.
The law says that it is not the, so the law actually absolves the doctor of all of everything legal implications. It is on the person to prove that the doctor is just there to do the work. It is, if the paperwork is fine, the doctor is just doing the job. He cannot be held medical legal implication. The doctor cannot be held for any wrongdoing in this.
Only in this case, the doctor should not do one thing, that take the eggs from one lesbian partner and put it into another. That would be the most
No, that
criminal
is
thing to do.
No, the
That
partner
we
what
should
is
not do.
involved in here.
If a single,
I
one
think
of the lesbians, if you're doing with, the same eggs and implanting the baby within her, that's very legal with the correct paperwork.
Okay. So scenario 6, Dr. Aarti?
Yeah, it is another common clinical situation because the women are becoming financially stable and they're not finding a partner as per their choice and qualifications. So this 30-year-old financially stable single lady visits IVF clinic to get her eggs frozen, and she has a wish to have a baby by donor sperms. She's neither a divorcee nor a widow. So what is the doctor supposed to do for her?
She can go ahead.
Go ahead and do
It is
it.
very
Yeah.
much doable, ma'am.
Yeah.
no, according to the ART,
This is
No, the law says don't do it.
don't
The
do it.
Oh no,
criteria is she has
Not
to
surrogacy
be
नहीं.
married.
Surrogacy नहीं कर सकते मंदिर.
अरे सिंगल
IVF कर
मदर
सकते
सिंगल
हैं.
IVF
मदर
कर
कर
सकते
सकती है
हैं.
Single mother.
surrogacy की
IVF
बात
कर
नहीं हो
सकते
रही
She
हैं.
has
सिंगल
to be
मदर कर
either a
सकते हैं
Not
divorcee or
single
a widow.
mother.
No, that is
No,
No, no,
IVF कर सकते
single
हैं.
mother.
a single woman can use ART services.
Yes,
Yeah.
but cannot use surrogate.
Perfectly,
Absolutely, they can go ahead.
perfectly
She's
okay.
never married.
She is not married. She is not divorcee. She is not a widow. I
Yes,
think
you
according to
cannot
the
do. You have
Indian
to
ART
go through it
regulation,
again.
No,
she
she
cannot
can
go
do.
for
She
ART.
can,
As
she
per
can.
law, she can do.
She can have her baby. A
Can.
single woman
We will
can
write in the group. We will put the
Okay,
clause in the
okay.
group.
Carry
Divyanshu,
on.
No,
Divyanshu
no,
will give the
please.
final word. Divyanshu?
She can.
She can do it. She can do it. What is
हाँ
there?
single mother allowed है.
Ma'am,
Allowed.
she can go forward for IVF treatment.
Yes.
IVF
Yeah,
treatment, she can go forward.
But
21G
don't
allows
do.
you to do that.
Yeah,
The
she
law
can take
allows
ART.
it.
Section 21G allows you to do
Excuse me.
that.
Excuse me, I have a doubt in this case. If she wants some person, known person to use her his
Yes,
sperm,
yes.
can it be done?
Routing through ART bank.
Through
That
ART
is a
bank.
big question.
Routing through ART bank.
Huh?
ART.
इजी हो गया ना अब, पहले मुश्किल था जब
Donor
गाइडलाइंस
embryo
फॉलो कर
also.
रहे थे.
True.
पहले मुश्किल था,
हाँ
अब इजी हो गया.
अब easy हो गया.
Next case.
Next. Okay.
I think we need to stop.
Dr. Sonia next.
Dr. Sonia has, I think, left
In the
or what?
previous case,
No,
I have a
I'm very
query.
much
No,
here.
No, she's
is
there.
there.
Man is there. Man is there.
Our
Man is
expert
there.
is here.
I'm here.
Can we
I'm here.
take another case?
So married couple has 4 frozen embryos and they die in an accident and their parents wish to have a child through a surrogate.
No.
See, if
Ladki
they
refuse.
if there has been any, documentation.
No. Donor
No,
donation is not allowed
the
in
form does
surrogacy.
not say anything. The form does not say anything beyond couple. So this is where what we heard in the first lecture, the embryo disposition agreement. That's how important it becomes because these are the gray areas.
No. Embryo donation is not allowed in
No, no,
surrogacy.
no.
It is
No, no, I'm
completely
saying
Parents,
what,
parents.
what Mohini ji told us about the embryo disposition agreement. So this,
Yes.
and now I'm feeling that that EDA is really the need of the hour.
The gametes authority is given to the parents of, मतलब the grandparents हो गए ना वो.
हाँ, grandparents की age
Then
criteria हो
also,
जाएगा.
then also you cannot do it, ma'am.
Cannot do it.
कर सकते हैं ना second
It,
generation.
you cannot do it. Recently, a case was permitted in Delhi. Posthumously, surrogacy was allowed, but it is still stuck at the level of appropriate authority itself.
Because
It
there was
has
no
not
consent
been
from the
allowed,
dying
but it
persons.
has not reached its
Yeah.
culmination yet.
Yes.
Yes,
Because the
ma'am.
people who have died did not give consent that their embryos may be used later on posthumously. That consent is not there. So therefore they cannot use it for in a surrogate.
क्योंकि
It's only
हमारे
when the consent is
हमारे
already there,
हमारे
then
कंसेंट
you
फॉर्म
can
में
hand
तो
it
दो ही
over.
क्लॉज है ना मैम,
तो
एक
मैम
the
अगर मान
wife
लीजिए
और husband.
कंसेंट दी होती तो भी तो ग्रैंड पेरेंट्स सरोगेट कैसे यूज कर सकते हैं, उनकी एज भी तो ज्यादा होगी नहीं.
वो तो ये बताएगा कि whether they can be used or not, but
Ma'am,
हाँ,
it cannot be used as of now as per the
as
act,
not now,
but
yes.
Justice Pratibha M. Singh had given a nod for this. The
Yes,
judgment is very nice. I'll share it in the group.
Very nice judgment.
It is
Yes.
very progressive. It is very progressive when it comes to this. So the ART board has also been instructed to look into this about the posthumous reproduction.
ओके, सिनेरियो 8.
अच्छा, हाँ, ठीक है.
मनदीप नहीं मानेगी मैम, वो अपने पूरे 9 केस
हाँ
करेगी.
करेगी. करो.
फटाफट मनदीप.
बहुत मैम मैंने दिमाग लगाया है इसके
I know
ऊपर.
they are good cases, Mandeep.
Very good cases, yes.
Cases really.
Very interesting.
Quickly. Yeah.
Okay,
Let's
so a
go.
donor gives 12 healthy eggs, and the law prohibits to use more than 7 to 8. So 5 oocytes were frozen for the same couple. So no blastocysts were formed in the first culture. Now for the next thawing and re-ICSI, the patient refuses. They say that you should have foreseen this, कि पहले जो eggs use किए उससे embryos बने नहीं, अब पैसे देंगे इसके. So who is at fault?
The clinic has to take the onus.
Why?
But Mandeep,
Mandeep, no, again, like Dr.
From
Umesh
one
Jindal
donor,
said,
if you have taken proper consent, if you have documented and we have done the proper counseling that this can happen in any procedure we are doing IVF, this happens sometimes. So if we have taken the consent, the onus is on the couple itself.
So I mean, my question is that should we inform them that, this donor gave 12 eggs and we used 7 and now we've frozen rest for you? Or we
कोई
should just...
पेशेंट हमारा सगा नहीं होता है, याद रखो. No, never go against the law, to be honest to patients. And first of all, by the law, you can only be documenting 7 eggs. So those 5 which you have frozen, how you're going to prove that, from one
No,
cycle.
you have to write it in your file. That
I
we
think
should
there
not
was
have
a
frozen them in
this
the
is
notification.
first place.
absolutely
We should
legal.
not have
There was
frozen
a
them.
not
there was an
legal.
amendment. There was
Yeah,
a
there was an
notification. I don't.
amendment in April.
Yes.
See, there was an amendment 5th April 2023. Like Dr. Jindal says, you should see the spirit of the law. It does not want OHSS to be happening and donors to be
Yeah.
suffering.
Yes.
So the intent is that you have to just save the donor from OHSS. You can please go ahead and do the culture or blastocyst culture for all 12 in one go.
Okay.
Say out of those 7 eggs, you get 7 embryos. What
Please share the amendment in the group, please.
Yeah, I'll share it 5th April 2023. Yeah.
Okay, Dr. Aarti, please. Last case.
Yeah.
She is sitting in
I
Prague
would
and
like to point out.
still,
I would like to point out one thing.
attending the meeting.
One second, excuse me.
Dr. Parag wants to say something.
I would like to point out one thing. The amendment, most probably the amendment she is referring, that is the amendment was regarding that if the patient is having this much follicle, and you have to remove you can take out all the eggs. It's not like that you can use all the eggs.
Yes,
Can't
yes.
freeze them.
You should not leave. There was a confusion that
Yes.
if the patient is, suppose मान लो के 15 हुआ था, and 15 follicle, if you are just picking out only 7 and you are leaving all the eggs inside, so there will be a medical condition. So
Complicated.
for that amendment came, which told us that yes, you can take out all the eggs, you can vacant all the follicles, and you have to use only 7.
Yes.
And there is no confirmation about that the rest of the things you can freeze it for future use.
नहीं ऐसा
There was nothing written in
डॉक्टर
the law.
नंदी ऐसा नहीं लिखा है कि यूज आप 7 कर सकते हो, ऐसा कुछ नहीं लिखा, ये लिखा है कि ऑल द एग्स शुड बी यूज्ड फॉर द सेम पेशेंट.
Yes.
No,
So
no,
that
no, 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 no.
ऐसा कुछ नहीं है कि 7.
डॉक्टर पराग, तो फिर आप लोग क्या करते हो 7x यूज करने के बाद बाकी?
No, we discard.
No, why will you waste it? You will freeze them for
No, you
presentation.
discard. No. The law, the particular. I think the lawyer is there. He can opine on that. The gadget which she is referring, that gadget is. I have gone through each and every. There are tricks are there in the. You just once. I don't have right now in front of me. But you can go ahead with the particular amendment.
I will write that in the group. I have read that.
I think 33 or 34th amendment, the gadget, and that gadget.
Eggs can be used for the same patient. That has been written. I'll be putting there only.
This is the gray area where people in different parts of the country are interpreting it in their own ways. So we attended a panel discussion of, I think, ISAR in Ahmedabad, where Dr. Gitender was conducting the panel. And all the panelists, all the expert panelists, everybody was of a different opinion. So one of them was saying that you should look at the spirit of the law, that the law is made to safeguard the health of the donor, and not to use the donor as a treat her like a human being, and not overstimulate her. But the law is not telling. So one of the very senior persons sitting in the panel was saying that use all of them. The law does not prohibit you. And some of the people were saying that no, use only 7. So this is the gray area where people are interpreting the law in different ways. And on a
overstimulate तो वो हो ही गई है 15 मिल रहे हैं तो
नहीं 15 is not overstimulation. It will be M1.
According to law, we know it is not, but according to law.
And on a lighter note, previously I used to like donors who had to like full ovaries, Now if the donor is having lesser number of eggs, like 7 to 8, I really love it that there is no, there's no wastage now. These many eggs will be formed and it's good. Like lesser number of eggs is a good donor now. Because otherwise it gets wasted.
Please, next case, dear.
Okay, so Dr. Aarti.
Okay. So this is again, we get to see this kind of scenario. A couple permanently moves to India and they want to shift their embryos frozen in an IVF center in another country. I had a similar one frozen in US. And instead of going for permissions to embassy and civil authorities, they visit the clinic regularly and create a lot of pressure on the doctor. And they are not going to the embassy and they are putting poor reviews for the doctor, that the doctor is not helping them, and they are on social media against the doctor. How do we handle such situation?
They have to go through the embassy. There's no other way out. We have to counsel them and guide them. We just cannot get under pressure and do anything wrong in this scenario.
So,
Ma'am,
I believe
there's
rules
something.
for
DGFT.
media patients also. This is for Divyanshu.
DGFT has strictly banned this. You cannot import embryos or gametes from outside. So this is not allowed in the first place. There is a specific order for that.
In the ART law, they have
Ma'am, you can export it.
Given
You can
consent
export
forms.
Ma'am, you can export it. You can take it outside.
For shifting embryos from one place to another, even outside India also.
Yeah, so
yes,
you can export but not import.
Outside. You cannot import. You can export.
What is the logic, please? What is the logic?
We just have to explain the patient, right?
They might do
The
SD.
logic is
They might do SD if you do import.
Yeah. And then bring the embryo from there. That's where they don't want.
Mandeep, we can
it
stop
is
here so
this
that we
this
can.
They
this
could have been
act
sex
is an
selected. Okay.
Yeah.
Yes. So this act is an extension to the PCPNDT Act. It clearly states that in the act. So the intent is to not import is so that no sex selection or any procedure as such should have been done on the embryo or on the oocyte or earlier there. So
So
that
that
is why they
means,
have barred
so
this.
that means, Divyanshu, they will never allow it, even if they go through court or whatsoever. They will,
No, ma'am. No, ma'am.
So
They
No,
this
will.
is
ma'am.
absolutely no.
And I think, in this contest, government is absolutely right. And
Right.
I
Yeah.
see it has been
Yes.
done.
Yes, the logic is good
नहीं
and
तो
appreciate
Very
आदमी
nice.
का
we
आदमी
appreciate the
import करना
logic.
होता.
Very nice.
They would have got
Okay.
sex selection done anywhere in the world, and then they brought us to our heads to do embryo.
Yes.
Okay, so we come to the end.
And Mandeep, the last question: stimulation of the patients going to Thailand, Bangkok, and Dubai. What to do
I am
about
not
that?
doing. I am not doing.
That is a great.
Divyanshu, is it
not doing
legally
it.
correct or not?
See, we are not doing it. We are not entertaining
We
those
can't
people.
assist them in any.
So
Yes,
again,
yes.
you have to go by the spirit of the law.
Yes, ma'am.
Anything which you are aiding a sex selection procedure, you are party to it.
Here, so
True.
So it's not that you can separate out इसमें होगा इसमें नहीं होगा, but if it is proven that you are party to that process, you are guilty.
True, very true.
True, ma'am. True, ma'am. True, ma'am.
Okay, so we come to the end of our panel discussion, and it has been very interesting talking to everyone. And I think we should have more such discussions for our enlightenment, because there are so many gray areas in the law where we are not so clear. And I think discussion brings a lot of logical points to our minds.
My request, please, somebody put that, donor egg stimulation.
Yes, I will put that.
Please, because even I feel 7, but if there is some change, I would love to know.
Yeah. Dr. Aki has already put
Already shared.
one document. Yeah.
Thank
PDF
you
is
so
there.
much. I think we need to wind up the session now.
Yeah, excellent.
Very
Neeti?
excellent session. I think we were, in our SIG, we were thinking of doing one, webinar with every zone, but I think we have to come back to North Zone again because you people are so enthusiastic and the discussion has been really. One more webinar once. North Zone. Thank you, Dr.
North Zone is really happening. Zone.
And your patients, I felt that your patients are really troubling you.
Yeah, so I asked once one district appropriate authority that, there are doctors who are promising that, okay, we will increase the chances of having a male baby just out of, I think, desperation. Because when the patient sits on your head for 2 to 3 hours, doctor ji, bas 55% कह दो, 55 कह दो, 50 नहीं, 55 कह दो. I think that person, just to throw them out of the room only, it's so frustrating.
I can understand. I
That
can
is,
feel the
Mandeep, very
frustration.
wrong because you can
No,
take
I
it
know,
from
ma'am.
your
I
head.
don't say, but I am telling you that when district appropriate authority comes, I say, what action do you take against such people when they promise patients that we increase? What action are you taking? I mean, they should have some people going around and with some secret cameras and sending some patients to stop these people from promising
Answer one
patients. I mean,
question.
what is
Answer one
there?
question. Answer one question, Mandeep. When you know that this person is doing it, have you ever reported that person to the authorities? Not one of us has reported a person who is actually doing these things. We don't report.
Nobody wants to be whistleblower, ma'am. Nobody wants to be
Nobody wants
whistleblower.
to be a whistleblower, right?
Yes.
और मैम
We have
पेशेंट्स
no right to complain. We should not.
जो पेशेंट्स आके कह रहे हैं मैम वो भी तो इक्वली कल्प्रिट है ना जो आके
तो
डॉक्टर्स
फिर
को
तुम
कंप्लेन
सामने
कर रहे
बैठे
हैं
रिपोर्ट कर दो ना. यू आर सपोज टू रिपोर्ट इट इमीडिएटली टू द अथॉरिटी कि मेरे पास सामने एक पेशेंट आया एंड ही इज आस्किंग फॉर सेक्स सिलेक्शन.
I think we can reform ourselves. We cannot reform the society.
we can
That
form
is
a
the
group
only
and
thing
do
we
this.
can do.
As
I
Dr.
think
Umesh Jindal has rightly
We can
said.
only practice by our ethics.
Yeah.
Yes, we can form a group and we can report it. Yes, I agree.
Neeti, Please
ma'am.
note this. This is being recorded. So we are making a group now, ethical group, who is going to do all the ethical things.
And
Note
once again, I'm inviting you people to join the SIG. So in our group, which is there, anybody who is interested,
We can join. We all can join.
Maybe we can't have, we need people who are like really interested and ready to put in effort in the group. So anybody who's interested, please let me know. I will make you join the RSIG WhatsApp group.
Yeah.
Thank you, ma'am.
Thank
Everyone.
Thank you so much.
Thank you so much.
It was a
Thank you, Dr.
wonderful
Parag.
CME.
Thank you.
Thank you,
I,
Umesh.
I would like to
Thank you,
just, I have retrieved that particular PDF. It is saying, I'm just reading it out. It is saying that for retrieving oocytes from the donor, clinics shall make efforts to retrieve not more than 7 oocytes during one cycle, provided that the clinics shall retrieve all formed follicles. And the next line is the clinic shall ensure the controlled ovarian stimulation of women in order to prevent ovarian hyperstimulation. There is
That is
nothing written
already
like
being
that you
done.
cannot use. You can use.
That you cannot use it. Yes, Dr.
You
Parag.
cannot
Yes.
use also, it is not written.
It's not
Correct.
written that you cannot
Yes,
use.
yes,
It's
that is a
not
gray
written that
area.
you can use. That's
Yeah.
the gray.
If it
That's
is
the
not
gray.
written, that how we
You don't
will
need to
think
throw
about
them,
that
Dr.
and we will
Parag.
justify the
Don't
thing.
throw
That is,
them.
Yeah.
Don't throw
yes.
them.
It doesn't say you can't culture more than 7. It is silent on the law is silent on how many you can culture.
Yeah. You don't need to throw them.
Divyanshu, what is your take on this, being a lawyer? What is your legal advice to us on this?
Ma'am, it should be preserved.
It should be preserved.
Be preserved, yeah. Donor मिलते नहीं है
I
preserve
just wanted to add one more thing, ma'am. I just wanted to add one more thing. Final thing. Final thing. Somebody had
मैम एक बात
asked in the
बताओ,
beginning itself.
सिंपल है, 9 के नीचे तो पोसाइडन है,
और
9
क्या?
साइड्स के नीचे तो पोसाइडन है. आप अपने रिसिपिएंट को 5-6 एग्स दे रहे हो, 9 के नीचे तो पोसाइडन हो जाता है.
हाइपर रिस्पॉन्डर दे रहे हो तुम पेशेंट को.
हाँ.
बिल्कुल.
Okay, thank you so much. Good night, everyone.
Good night. Good night, everyone. Wonderful panel. Thank you very
Good
much.
night.
Working so hard,
Thank
Aarti
you.
and Pradeep. Thank you very much.
Thank you, ma'am.
God bless us all.
Bye-bye.
God bless you. Thank you, Divanshu, our guest. Thank you,
Thank you,
Parag.
ma'am. Thank you.
Everyone.
Thank you.
Bye-bye.
So much.
Thank you for inviting me here.